All right, looks like we are now streaming live. So that means if with that, it's 1 o'clock. So we'll go ahead and get started. One moment, because I know there's something I need to click off of so I don't have feedback. All right, I'm clicking off the YouTube portion. And I don't think that changes anything for live stream. There we go. All right. Good afternoon to you all. My name is Stephanie Rubenstein. I'll be the presiding judge in this matter. We have our score keepers are all present. And so I know I have gotten a roster from the defense. And if that's available from the plaintiff, that would be great. If it's not, what I'm going to have everyone do is introduce themselves as well. Let me ask first, plaintiff, are you ready to proceed with trial?
Yes, Your Honor.
And defense, are you ready to proceed with trial?
Yes, Your Honor, after a few preliminary matters.
All right. I'm going to go through my preliminary matters first, and then before opening statements, I will ask both sides if they have anything before we get started. All right. I see the timekeepers are present. There's a statement on my list of things to discuss about photographs being taken. I don't know how much that really applies in this process, but the Colorado Bar Association may be taking photographs of the competition, and that team participation grants automatic permission to use those photographs. We've discussed, I don't think there's anyone that's present in the gallery that's not supposed to be here. Do recall that there are not going to be any recesses with the exception of a health emergency. However, if there are any issues related to technology, I've got the chat up, but at the same time, sometimes I might miss that. So anyone feel free to just let me know if there's someone missing or someone's dropped off. We'll be patient with one another as we try to get through this, because this is a challenging way to do this. But just let me know if there are any issues along the way and we'll work through them. For the 3 scoring panelists, in looking at the names in front of you, did you see any names that cause you concern about being biased towards judging any team? And before I do that, let me back up. One of the things that I've heard from the first round is that it helps the scoring judges even if you're playing a witness, if your personal name is listed as part of your screen name, that helps them to know who you are and get you properly scored. So I see a couple of places where there are names listed or just attorney, but if you could have your name up there, that helps a lot. But I am also going to ask you if you can remember to do this, and I may remind you then, as a witness, please state your name whenever you are testifying, your personal name as well as your witness name. And then again, that just helps the scorekeepers make sure they get everyone scored properly. So I'll ask, let's see. I'll start with the plaintiff. If the plaintiff's attorneys could introduce themselves first, and then we'll have the witnesses introduce themselves first for the plaintiff.
Good evening, Your Honor. My name is Hollis Andrew. I will be presenting the opening for the prosecution, direct examining Kyle Kuzak, and cross-examining Avery Becker.
Thank you.
Good afternoon, Your Honor. My name is Madeline Herman. I'll be direct examining Alex Cifuentes and cross-examining Taylor Perkins.
Thank you.
Good afternoon, Your Honor. My name is TJ Newman. I will be direct examining Professor Blake Van Owen, or direct examining Detective Jordan Markowitz, cross-examining Professor Blake Van Owen, and doing the closing statement.
Thank you. Now for the plaintiff witnesses, you could introduce yourselves, please.
Good afternoon, Your Honor. My name is Bryn Geiger, and I will be playing the part of Detective Jordan Markowitz.
Good afternoon, Your Honor. My name is Kiara Warren, and I will be playing the part of Alex Cifuentes.
Good afternoon, Your Honor. My name is Camille Denman, and I will be playing the part of Kyle Kuzak.
Thank you. Attorneys for the defense, could you please introduce yourselves?
Good afternoon, Your Honor, members of the jury. My name is Kate Malloy, and I will be presenting the opening statement as well as conducting the cross-examination of Detective Jordan Markowitz and the direct examination of Taylor Perkins.
Thank you.
Good afternoon. My name is Bridget Carrington. I'll be conducting the cross-examination of Alex Cifuentes and the direct examination of Avery Becker.
Thank you.
Good afternoon. My name is Pilar Melendez. I will be conducting the cross-examination of Kyle Kuzak, the direct examination of Professor Blake Van Owen, as well as presenting the closing argument. May our witnesses introduce themselves?
Yes, thank you.
Good afternoon. My name is Caitlin Brennan, and I am Professor Blake Van Owen.
Good afternoon. My name is Anna Kabuchin, and I am Taylor Perkins.
Good afternoon. My name is Hannah Feeney, and I am Avery Becker.
Thank you. I have to say, I'm impressed with how everybody got introduced so smoothly. I've seen groups of lawyers not manage it as wonderfully as you all just did that. That was awesome. For the scorekeepers, is there anything about any of the folks that just introduced themselves that causes you concern that you may be biased against judging any team? I'll start with, let's see, Ms. Butler, are you on? Am I on the right? I see Mr. Kane. I thought I had all three of my scoring people, and maybe I've got different people on. Ms. Oates. And Ms. McEwen. Okay. Anything about any of these witnesses that causes you concern, or these parties that cause you concern about bias?
Not for me.
None for me.
Great. Thank you all very much.
Judge, can we just get the team code names?
Thank you. For the plaintiff, do you have that available?
Your Honor, we are maroon.
Okay. And for the defense?
Your Honor, we are Team Evans.
Evans?
Yes, Your Honor.
Perfect.
Evans,
Okay, thank you.
EVANS.
Thank you. Any other information the scorekeepers need? Okay, I'm hearing none. I'm going to move forward. I'll remind the teams and coaches that any disputes that arise out of this competition must be reported in accordance with the competition rules. There are certain things I can handle, but others that need to be reported to the tournament directors after the round. Your compliance with time requirements will be considered in scoring scoring individual performances. I think that's all in terms of my preliminary statements. I am first, however, going to swear in the various members of the teams, and I'm going to start with the team members, the lawyers. If you could all raise your right hands. Team members, do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
Thank you. For the witnesses, next, I would ask that you please raise your right hand. Witnesses, do you promise that the testimony you are about to give will faithfully and truthfully conform to your witness statements, that you will not add material, facts, or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition?
Yes, Your Honor.
Thank you. And I know I see a coach, so I'm going to swear him in as well. If any other coaches or other that are present, I would ask that you please raise your right hand. Do you promise to represent yourselves as a positive role model and to behave in a manner that exemplifies ethical and professional sportsmanship during and after this mock trial round?
Yes, Your Honor.
Thank you. And lastly, the scoring panelists, could you please raise your right hand? Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
Yes.
Yes.
Thank you. That concludes my preliminary directions to the parties. Plaintiff, before we get started, are there any preliminary matters?
Yes, Your Honor. May I proceed?
You may.
First, the court should already have a copy of the trial roster, which we provide in advance of the competition. Please let me know if you do not have this.
I don't have that for the plaintiff. And it's, I'm sure you've provided it to the to the folks that needed to. If you don't have it or can't get it to me, I can also email the directors and have them provide that to me.
Thank you, Your Honor. I would also like to constructively provide a copy of the stipulations to Your Honor and inquire whether the juries have copies as well.
And you may provide that to me. And the scoring panelists, you have that as well?
Yes, I do.
Okay, and that's part of the packet, is that correct? Is there anything other than what's in the initial packet, Mr. Andrew?
No, Your Honor.
Thank you. Any other preliminary matters from the plaintiff?
Yes, Your Honor. In terms of admitting exhibits, the co-counsel and I will be asking permission to share screen exhibits for purpose of establishing foundation, and then we will specifically ask to publish.
Thank you. Anything else?
When identifying the defendant, Avery Becker, we would ask the defendant to turn on his or her camera for the purpose of identification. We
Very
will.
good.
Them. Okay. Thank you, Your Honor.
Thank you.
We would ask permission to stay seated during our presentations for purpose of audio-visual quality during the proceedings.
Such request is granted for all parties and witnesses as you are comfortable. If you are more comfortable standing at any point, you are welcome to do so as well. Thank you.
And lastly, Your Honor, we would ask permission to raise our hands as we object in order to alert the court that we have an objection in lieu of standing. Again, to the audio-visual quality.
That would be appropriate. Thank you.
Thank you, Your Honor. No further preliminary matters.
Thank you. For the defense, do you have any preliminary matters?
Yes, Your Honor. Firstly, I would like to draw attention to the fact that the genders of all of the defense witnesses have been placed in the Zoom chat. Additionally, the roster is there as well, as I'm sure you've noticed. I would also like to bring up the fact that similar to the prosecution prior to the trial today, we will be verifying a few of the mechanisms of the online trial that we will be participating in. In particular, the defense will be following special rules for the admission of the exhibits as outlined in Rule 7.4 of the Rules of Procedure. This just means that while the exhibits are displayed on the screen, they will not be shown to the jury unless we specifically ask to publish them. Additionally, while each of the attorneys and witnesses have made efforts to be in a setting with the best possible internet connection, if at any point you cannot see or hear any of us, please feel free to let us know.
Very good. Thank you. And as I stated earlier as well, any of the team members will not be considered in any way disrespectful by interrupting me or the proceedings in order to let me know that someone has dropped off. We're all working into this together, and so please feel free to do so that we make sure that if I miss something, we've got everyone present. Thank you.
Yes, Your Honor. Your Honor, furthermore,
Yes.
all witnesses will be considered present for the trial today, as there is no constructive sequestration pursuant to Rule 5.3.1 of the Rules of Competition.
As my understanding of the rule as well. Correct.
And can the court clarify as to whether or not it intends to constructively read the jury instructions prior to or after closing argument?
And so by constructively, because you're taking me off my my script, so I'm not sure. I have reviewed the jury instructions, and I believe it's in the packet that has been given to the jurors. And so beyond that, there will be no further reading of the jury instructions. If you want me to address it in some other way, let me know if I've missed what you're asking me.
Yes, Your Honor. May we have permission to reference the jury instructions in our closing arguments?
Yes, of course. Yes.
And lastly, we are just confirming that the court and the jury have copies of the complaint information and that all preliminary matters have been incorporated into the record.
That would be accurate, yes.
With that, Your Honor, I have no further preliminary matters.
Very good. Is plaintiff ready to proceed with opening statement?
Yes, Your Honor.
Whenever you're ready.
Burglary turned to butchery. A clearly planned burglary had gone wrong. Avery Becker sits in front of us here on Zoom today, prepared to escape the cages of her crimes. My name is Hollis Andrew, and as the prosecutor in this case, it is my pleasure to represent the people of the state of Colorado. Avery has had a life of little struggle, has had good friends, good grades, and specifically, good skills in her mock trial club. Avery seems to be able to craft her words with ease, always able to lure the judges and scorers to her side. The only thing to revolt and rival Avery's talent was her coach, Mr. Brackman. And oh, did she dislike him. He was always telling her to prepare, always taking credit for her success, putting her on the B team, taking credit, always. Avery, in rage, graffitied his car with permanent pens. Revenge. Something Avery had never had the likes of before. Was Avery done? No. Avery was angry. Brackman had kicked her off the team for her outrageous actions, and yet anger dwelled too deep for remorse to matter. Avery planned on burglary. Planning to break into Mr. Brackman's home, Avery was so confident, she even informed her classmate Alex with a series of texts. Right here. And here I quote, "Well, if he's upset about his car, then he's gonna be really upset when he sees what I do to his house." On March 6th, at Mr. Brackman's residence, her reunion with revenge finally came. Avery's phone had connected to cell towers near the house, and Avery had successfully intruded into Mr. Brackman's residence, planning on burglary. But Mr. Brackman's security cameras caught Avery and alerted him. Mr. Brackman armed himself with a knife, and unfortunately, in the ensuing struggles, he was killed with the same knife he introduced into the encounter. Avery had got more revenge than she had bargained for, and that's what brings us here today. Burglary turned to butchery. Me and my fellow attorneys will show, and witnesses, will show this Zoom meeting the truth of the matter. First, Detective Jordan Markowitz will tell us about the Ring camera recordings of Avery's burglary, Avery's texts, and also the location information of Avery's phone. Then Alex Cifuentes will tell us about the rivalry that Avery and Mr. Brackman had against each other, the graffiti Avery did, and the blatant texts Avery sent of her intentions. And finally, certified crime scene reconstruction investigator Kyle Kuzak will lay down exactly how the victim was murdered. She will show us a step-by-step reconstruction of how Avery murdered Coach Brackman. No matter how much the defense twists their way through this case, or how much Avery tries to persuade you, her burglary turned to butchery. Judge, members of the jury, at the end of this case, we will ask you to find us justice and to find Avery Becker guilty of first-degree murder and second-degree burglary. Thank you.
Opening statement for the defense.
Yes, Your Honor. Before I begin, I would just like to object to the use of Exhibit 14 in the opening statement. I would object facts not in evidence, Your Honor. My apologies. I believe you're muted.
Thank you. I note the objection, and should it, and it may be addressed in closing argument as well, should it not be entered into evidence throughout the hearing.
Yes, Your Honor.
Hang on one moment. Mr. Andrew, would you like to respond?
May I please confer with my counsel before I respond?
You may.
Your Honor, I
Yes.
do not have a response. I'm willing.
Right.
Yes, sorry.
I'm sorry, you do or do not? I cut you off, I think.
Do not.
All right, thank you. You may proceed with your opening.
Yes, Your Honor. May I have a moment to rearrange my virtual courtroom?
Yes.
May it please the court?
Yes.
The prosecution just made you a lot of promises about what Detective Markowitz and Kyle Kuzak will say. And they also made you a lot of promises about what happened on March 6, 2020. Now, in today's case, we must listen for the alibi, the alternate suspect, and the awful investigation to understand what's really going on. Now, Avery Becker has an alibi, Blair Rollins is the alternate suspect, and the prosecution conducted an awful investigation. Again, the prosecution just made you a lot of promises about what Detective Markowitz and Kyle Kuzak will say. Hold them to those promises. And you don't have to take just my word for it. Today, you are going to hear from Professor Blake Van Owens. Professor Van Owens is going to tell you all about the prosecution's assumptions and incompetence. You are going to learn that the prosecution's theory is like a house of cards. If one falls, so do the rest. The truth is, the prosecution's star witness, Alex Cifuentes, could be completely framing Avery Becker. And we will never know because the prosecution conducted an awful investigation. How can we know what really happened? Well, when it comes to Avery Becker, the truth lies in the alibi, the alternate suspect, and the awful investigation. As you listen to the prosecution's evidence here today, ask yourselves these three questions. 1, what time did the victim, Mackenzie Brackman, actually pass away? 2, where has Blair Rollins been since March 6, 2020? And 3, how can someone be in two places at once? Remember that at the end of the day, we don't have to prove the prosecution is wrong. They have to prove they are right. And that is because the prosecution has the burden of proof in today's case. They must prove every element of every single charge to you beyond a reasonable doubt. That means that if the prosecution's evidence makes you hesitate, leaves your minds wavering, unsettled, or unsatisfied, they have failed to meet their burden and you cannot convict. Alibi, alternate suspect, awful investigation. Let's break that down and start with alibi. Avery Becker couldn't have committed this crime. And that is because she was in a public place with Taylor Perkins all day on March 6, 2020. But you don't have to take my word for it. You will hear from Taylor Perkins herself. She will tell you how she spent the day looking for Avery's phone. Now let's talk a little bit about the alternate suspect. Today, you are going to hear all about Blair Rollins, but you won't actually hear from Blair Rollins. And that is because the prosecution's awful investigation never looked into Blair Rollins. Now, despite that, you're going to learn that Blair Rollins matches the height and build of the suspect. You are going to learn that Blair Rollins has a motive to kill Mackenzie Brackman. And you are going to learn that Blair Rollins has not been seen since March 6, 2020. Lastly, you will hear from Avery Becker herself. Ms. Becker did not have to testify today. She is choosing to waive her constitutional right not to testify today, to come here and look each of you in the eyes and tell you what really happened. The prosecution says a burglary turned to butchery. The defense does not argue that a burglary may have occurred, but the prosecution expects you to believe that Avery Becker is guilty, despite the alibi, the alternate suspect, and the awful investigation. If you hold the prosecution to their burden and remember alibi, alternate suspect, and awful investigation, I am confident that at the end of the trial today, you will return with the only just verdict: not guilty. Thank you.
Thank you. I had a question about doing a note or chat with a specific member of your team for purposes of conferral, which is permitted by the rules. On my screen, I just want to let you all know, under the to portion, you can do it to everyone in the meeting, but you also have the opportunity to chat with an individual person. So you just need to change that. There's a little arrow next to the to that allows you to do that. So if you wish to chat that's private and not displayed to everybody, so be very cautious in using that, but you do have that opportunity. If there are any further problems with that, chat to me and I will address it further. With that, plaintiff, you may call your first witness. Oh, yes.
First, Your Honor, I am not able to chat to the people I'd like to. I'm only able to chat to either everyone or the host.
Okay, so that's what I need to check on. And I will, just because the person, let's see, who just did someone from the defense, can you tell me, is that what you see as well?
Yes, Your Honor, I can only chat to you or everyone.
Okay, that's different than mine. So let me see what I can get changed on that, and we'll proceed right now with the first witness for the plaintiff, but I'll fix that. Thank you.
Your Honor, the plaintiff would like to call Jordan Markowitz to the stand.
Ms. Markowitz, you've already been sworn, so please state your name for the record and include your name to be scored under as well.
Bryn Geiger, playing Detective Jordan Markowitz, Markowitz.
Thank you.
And Detective Markowitz, what is your occupation?
I'm currently working with the Denver Police Department.
And how long have you been working for the Denver Police Department?
Yes, sir. I have worked there for 13 years, and I've been a detective for 7 of those years.
And during your tenure, have you received any specialized training?
Yes, sir, I have. I've received specialized training in cell phone technology and forensic data recovery from the American Academy of Law Enforcement.
And what did you learn during this course?
I learned how to obtain and interpret cellular data records.
And have you used this in cases before?
Yes, sir. I've used this in over 50 cases before.
Your Honor, we would like to qualify Detective Markowitz as an expert in the fields of cell phone technology, forensic data recovery, and cell tower analysis under Rule 702.
Any objection from the defense?
I get the defense attorney to say the last part of the qualifications once more for clarification.
Cell tower analysis.
I have no objections, Your Honor.
She is so qualified.
And what happened on Friday, March 6, 2020?
I was called in to investigate the murder of Mackenzie Brackman, a criminal defense lawyer.
And upon your arrival, what did you observe?
Yes, sir. Immediately upon arrival, I observed 3 Ring doorbell cameras surrounding the residence. And then inside the residence, I observed a knockdown chair, a broken plate, and blood spatters on the wall.
And Your Honor, permission to share what is previously marked as exhibits 1 through 4.
You are so permitted.
Thank you. And what do exhibits 1 through 4 show?
They show pictures, accurate pictures of the victim as seen from inside the house, outside the house, and a close-up picture of the stab wound.
And is this a fair and accurate representation of the condition of the victim upon your arrival at the house?
Yes, sir, they are.
Your Honor, permission to admit and publish to the jury what is previously marked as exhibits 1 through 4.
Any objection from the defense?
Yes, Your Honor. I would object that these are, pursuant to Rule 403, these are cumulative as well as more prejudicial than probative. There are multiple graphic photos of the victim, and this could sway the jury's opinion in today's case. Furthermore, as you can see, most of the photos are relatively similar, and therefore they are cumulative.
Response from the plaintiff.
Yes, these are not more prejudicial than probative, as they provide an accurate depiction of the condition of the victim to the fact finder. And then in addition, they are not cumulative, as they provide different angles on the photo and allow the fact finder to more accurately understand the condition of the victim.
Any further response from the defense?
Yes, Your Honor. As you can see, especially in exhibits, I believe that is exhibit 2 and exhibit 3, those are similar angles, and this is more prejudicial than probative as well.
Thank you. I am admitting exhibits 1 through 3. I do find that for the reasons stated by the plaintiff, specifically as to the cumulative objection, that the different angles would permit the different photographs, that there are 3 distinctly different documents. Further, in terms of them being more prejudicial than probative, based on the fact that these are being introduced via an expert in terms of this particular area, they are necessary for the jury to understand the nature of the charges, and therefore the objections are overruled by the defense. Continue.
Thank you, Your Honor. Permission to share was previously marked as exhibits 5 and 6.
You are so permitted.
Thank you. And Detective Markowitz, what do exhibits 5 and 6 show?
Exhibit 5 is an accurate picture of the knife used to stab Mackenzie Brackman as seen at the crime scene, and then the same weapon later seen at the crime lab.
And are these fair and accurate representations of the weapon that you believe was used to kill Mackenzie Brackman?
Yes, sir.
Your Honor, permission to admit exhibits 5 and 6 into evidence and publish them to the jury?
Thank you. Any objection from the defense?
Yes, Your Honor. I would once again object pursuant to Rule 403. These are cumulative and more prejudicial than probative. Merely one photograph of the knife would be sufficient to demonstrate the defense's point. 2 is overkill, for lack of better words, Your Honor.
Thank you. Response from the plaintiff.
Yes. As to being more prejudicial than probative, we feel that it has probative value, as it is necessary for the defense to understand what happened on March 6th of 2020. And then as to cumulativeness, we feel that exhibit 5 is important, as it provides an accurate depiction of what the knife looked like at the scene. And then exhibit 6 is important, as it provides a cleaner and better view of the knife, so that the fact finder can better understand the construction and shape of the knife.
Any further response from the defense?
Yes, Your Honor. I would then change my objection to relevance, as I do not see how a picture of the knife helps the fact finder to understand what happened that day, or how a picture of a knife in a crime scene helps the trier of fact at all.
Mr. Newman, response to that.
We feel that the trier of fact could be assisted in reaching the proper verdict by the knife, so that they can understand the cause of the victim's death.
Anything further from the defense on that?
Yes, Your Honor. If that is the prosecution's intent. I believe one photo is sufficient.
And as I stated earlier, I believe that exhibit 5 is there to provide an act to show the jury how the knife was upon arrival, and then exhibit 6 is there to show the construction of the knife.
The exhibits are not cumulative for the reasons just stated by the plaintiff. They are two distinctly different purposes between the two photographs. In terms of more probative, more prejudicial than probative, I'm not sure if that objection's been withdrawn since it switched to the relevance, but in any event, I do find that it's not too many photographs to have just the two, especially since they have specific purposes. And lastly, in terms of the relevance, the charges in this case involve the death of a person, and so therefore the method by which that happened would be a relevant inquiry, and so therefore the objections are overruled and exhibits 5 and 6 will be admitted.
Thank you, Your Honor. And what else did you observe upon arrival?
Yes. Inside the residence, I observed a knife block with a missing knife from it, and then as well as a knife drawer that was open.
Your Honor, permission to share was previously marked as exhibits 7, 8, and 9.
You may.
And what do exhibits 7, 8, and 9 show?
7, 8, and 9 are pictures of the knife drawer as seen at the crime scene, the knife block seen at the crime scene, and the broken plate seen at the crime scene, as I mentioned earlier.
And are these fair and accurate representations of the condition of Mackenzie Brackman's house upon your arrival at the scene?
Yes, they are.
Your Honor, permission to admit was previously marked as exhibits 7, 8, and 9 into evidence and publish them to the jury.
Any objections from the defense?
I have no objections, Your Honor.
Exhibits 7, 8, and 9 are admitted.
Thank you. And did you use the Ring doorbell in this case?
Yes, I did. I used 4 different videos from 3 different cameras in my investigation.
And are you familiar with the Ring system?
Yes, sir, I am.
And how does the Ring system work?
Typically, they are cameras set up around somebody's residence that are motion activated.
And how did you obtain the videos that were, how did you obtain the videos from the Ring doorbell?
Through the Cellubrite system.
And what is the Cellubrite system?
It is a system that allows me, a detective, to download data from my phone.
Your Honor, permission to share was previously marked as exhibit 12.
So you have permission to do so.
Thank you. And what is exhibit 12 a video of?
This is one of the videos I used in my investigation that shows the intruder entering Mackenzie Brackman's residence through the back door.
And is this a fair and accurate representation of the video you obtained from Mackenzie Brackman's phone?
Yes, sir, it is.
Permission to admit was previously marked as exhibits 10 through 13 into evidence.
And just so I'm clear, this was 12 and 10 through 13 was
10,
11, and 13.
Should we just 10 through 13 was 10, 11, and 13, 10, 11, 12, and 13, yes.
And what are,
Your Honor, would you like me to lay more foundation and ask the witness about what exhibits 10, 11, and 13 are?
Well, yes.
All right. And Detective Markowitz, what is exhibit 10 a video of?
That is a video of the intruder coming up to Mr. Brackman's front door and realizing it is locked.
And then what is exhibit 11 a video of?
Exhibit 11 is a video of the intruder coming in through Mr. Brackman's back gate, heading towards the back door.
And what is exhibit 13 a video of?
Exhibit 13 is a video of the intruder exiting, running the house through the front door.
And I would again request to admit exhibits 10 through 13 into evidence and publish them to the jury.
Any objection from the defense?
Yes, Your Honor. I would object more prejudicial than probative, as these videos show a suspect of a general height and build similar to the defendant in today's case. It could unfairly prejudice the jury into believing that the defendant is in fact the suspect. However, they have not laid a proper foundation as to whether or not they know who exactly is in these videos.
Any response from the plaintiff?
Yes, we are not purporting to know who exactly is in these videos, nor is that what we were discussing. So, and then in addition, we believe that it does have probative value that outweighs its prejudicial value, as it shows the way that the defendant, or that the likely killer entered Mackenzie Brackman's house, and how the scene of the crime happened.
Any further response from the defense?
Yes, Your Honor. Nevertheless, this could unfairly bias the jury against my client.
We do not feel that it could unfairly bias the jury, as your client is not in the video, or as your client is not visibly in the video.
In terms of the objection, I find that the proper foundation has been laid for authenticity, and find that it's relevant based on it being the date and time in question at the victim's home. I find that the objections go towards the weight that the jury is to give to this, and so therefore exhibits 11 through 13 are admitted.
10 through 13, Your Honor.
10 through 13, thank you.
Thank you. And what was your major break in this case?
Well, after some investigation, I found out that Mackenzie Brackman was the coach of something called mock trial at CHS, or more commonly known as Colorado High School. I then got in touch with the high school and got in touch with some of the students from the mock trial team last year, including a student named Alex Fuentes.
And what evidence did Alex Fuentes provide to you?
Alex Fuentes provided me pictures of screenshots of between text messages between him and another student on the mock trial team named Avery Becker, saying that Avery Becker was going to come to Brackman's house and trash Brackman's house.
And what are call detail records?
Call detail records are a record that is created when a call or text goes through a cell tower.
And what can these records provide to you?
They can tell you whether a call is incoming or outgoing, the date and time of the communication, what cell tower and antenna it went through, and who the sender or recipient is.
And can these antennas give the rough location of a phone?
Yes, sir, they can.
And how did they do that?
A given antenna will only cover so much area, so when a cell phone makes the connection with the cell tower, then you can pretty accurately determine where that phone was.
And did this allow you to place anybody's phone at or near the scene?
Yes, I placed Avery Becker's phone near the scene at the time of the murder.
Thank you, Your Honor. No further questions.
Cross-examination.
Yes, Your Honor. However, first, may I have a moment to rearrange my digital courtroom?
You may, and while you're doing that, I'll let you all know, I think I fixed the problem with the chat. I think I changed a setting, and so if you all could check to see if you now have the ability to chat with folks other than just the whole group.
Yes, we do. Thank you, Your Honor.
Perfect. Thank you.
Also, Your Honor, a bell here will ring at 1:45, so we will just mute and then we can tell you when it's over.
Understood. I appreciate the warning.
Good afternoon, Detective Markowitz. I'd like to talk to you about a couple things you said on direct. You stated that the phone was at Mackenzie Brackman's home?
Yes, ma'am. I stated that it was near Mr. Brackman's house.
So you stated that it was at or near, just to clarify?
It was near Mr. Brackman's house during the time of the murder.
Now, I'd like to start off by talking a little bit about the videos that you looked at in Say's case. You don't know what time those videos were taken, do you?
No, ma'am, I do not.
There are no timestamps on the videos?
No, ma'am, there are not.
In fact, you also don't know the time that Mackenzie Brackman died, do you?
No, not precisely.
And Kyle Kuzak's report mentions an interview with Taylor Perkins, isn't that right?
Kyle Kuzak, yes, I believe so.
However, you never mentioned interviewing Avery Becker's father.
No, I did not.
You never mentioned interviewing Avery Becker's mother.
No, ma'am, I did not, because Mr. Becker's lawyer said that all communication would go through her, and I figured that that would also include the parents.
That's not what I asked you. You didn't do it, did you?
No, ma'am, I did not.
In fact, you didn't interview anyone else on the mock trial team besides Alex Cifuentes, isn't that right?
No, I did not mention that.
In fact, you don't even talk about interviewing Taylor Perkins, do you?
I'm sorry, ma'am, that's not in my statement, but no, I did not interview Taylor Perkins.
Exactly, that's nowhere in your statement, isn't that right?
That is correct, yes, because the evidence that I gathered led me to my conclusion I didn't need to do any more investigation because the evidence I had already gathered.
So it's not in your statement.
That's correct, ma'am.
You never interviewed the 911 caller?
No, I did not, ma'am.
You never interviewed any of the neighbors, did you?
No, ma'am, I did not, because the evidence I had was sufficient enough for my conclusion.
All right, well, to be fair, you did interview Alex Cifuentes, though, isn't that right?
Yes, I did. After Alex Fuentes said that he had some evidence for me, I brought him in to interview him.
So you did interview Alex Cifuentes, and you got some text messages from Ms. Cifuentes, didn't you?
Yes, I did.
However, you never got Alex Cifuentes' phone, did you?
No, I did not. Unfortunately, Alex Fuentes did not bring her phone to the interview because being interviewed by the police can put a lot of stress on somebody and make people forget things.
You didn't do it, did you?
No, ma'am, I didn't, but I was provided with the screenshots that were trustworthy.
So you weren't able to use Celebrate technology on Alex Cifuentes' phone, were you?
No, I wasn't. As I stated earlier, Alex Fuentes did not bring his phone to the interview.
So you weren't able to prove that those text messages were real, were you?
No, ma'am, I was not. However, I'm positive that and pretty positive that they were real.
But you can't prove definitively, can you?
I cannot prove it now.
Now I'd like to talk a little bit about the alternate suspect in today's case. You know of Blair Rollins?
I'm sorry, ma'am, I've never heard that name before.
So you've never heard of one of the alternate suspects in today's case?
No, because the evidence that I've collected led me to the most reasonable suspect, Avery Becker.
And you're aware that Kyle Kuzak has heard of Blair Rollins?
I'm not aware of that, no.
So you didn't look into any other alternate suspects in today's case?
No, I didn't, because the evidence was pretty strongly pointing to Avery Becker. And it was not necessary.
Well, let's talk a little bit about Avery Becker's alibi. You never gave my client the chance to prove she had an alibi, did you?
No, I did not, because the call detail records placed Avery Becker at the scene.
So you didn't do it, did you?
No, ma'am, I did not, because it was not necessary.
You never looked into the claim that Miss Becker lost her phone?
No, I didn't. My investigation determined Avery Becker was the perpetrator.
So you didn't look into that claim, yes or no?
No, I didn't.
And you never reviewed Miss Becker's call detail records for the day prior to the crime?
No, I did not, because it was not necessary.
You didn't do it, did you?
No, because the phone was lost and it's not necessary.
The call detail records for March 5th could have proven whether or not Miss Becker had in fact lost her phone.
I suppose they could have, but it really wasn't necessary.
But again, we will never know because you didn't look into the call detail records. Isn't that right?
I did not look into the call detail records on March 6th, but the call detail records that I did look into for March 6th provided sufficient evidence that Avery Becker was near Coach Brackman's house on the day of the murder.
So nevertheless, you didn't look into those call detail records, yes or no?
No, I did not.
Thank you, Your Honor. I have no further questions at this time.
Any redirect?
Yes, Your Honor. Do you feel that after you had found a strong suspect that you felt was the correct response, do you feel like it was a a valuable use of police time to continue hunting down a valuable use of valuable police time and resources to continue hunting down asinine leads?
No, I did not, since the evidence that I had already collected gave pretty strong evidence that Avery Becker was the perpetrator and was the person who killed Mackenzie Brackman.
And do you feel it is a valuable use of the constituent of people's tax dollars to continue to go and look at leads that have little, that are unlikely?
No, I did not, since like I stated before, I had already had a very likely lead.
Thank you, Your Honor. No further question.
All right. Thank you. Plaintiff may call their next witness.
The prosecution calls Alex Cifuentes to the stand. We also ask at this time that Avery Becker turn on their camera for purposes of identification.
Thank you.
All right. Please state your name and spell your last for the court.
Alex Cifuentes, Sifuentes.
And who is Avery Becker?
Avery Becker is a classmate of mine and also a teammate on the mock trial team.
And what is your relationship with Avery Becker?
Avery Becker is one of my best friends, or was. She even got me into mock trial.
Do you see Avery Becker in court today?
Yes, I do.
What are they wearing?
A black shirt and a blue jacket.
Your Honor, let the record reflect identification has occurred.
The record will so reflect.
And Ms. Cifuentes, what was your relationship to Mr. Brackman?
Mr. Brackman was my mock trial coach and, well, my role model.
And would you say that your mock trial team did pretty well?
I would, yes.
Have any of your teammates received any awards?
Yes, last year at regionals, Avery received an award for Best Attorney Award and Best Closing Argument.
And just overall, have there been any incidents regarding work ethic of the team?
Yes, there have been quite a few.
Could you give us a specific example?
Yes, one main event that stuck out was a time when Mr. Brackman and Avery were arguing about Avery's lack of effort on the team and lack of preparation, and Mr. Brackman ended up kicking Avery out of practice.
And what did Avery do when she got kicked out?
She grabbed a permanent marker from the writing easel thingy.
And what happened next?
She stormed out of the class. I didn't find out more until later.
And what did you find out?
I found out that she had written on Mr. Brackman.
Objection, Your Honor, may I be heard?
You may.
Your Honor, the witness is testifying to an incident involving Avery Becker vandalizing Coach Brackman's car. This is improper character evidence pursuant to Rule 404A, as I anticipate that opposing counsel will use this as a character trait to show that Avery Becker was angry and hateful and acted irrationally and impulsively when she didn't get her way. And I anticipate that they will use that to say that she acted in accordance on the day Mr. Brackman was killed. Furthermore, pursuant to Rule 404B, this is also improper character evidence, as opposing counsel is attempting to use this evidence of a bad act in which Avery vandalized a car to show that she would act in accordance and vandalize Mr. Brackman's house, which is inadmissible pursuant to Rule 404B. And finally, this is substantially more prejudicial than probative, as it would lead the jury to believe that Avery Becker acts angrily and violently when she doesn't get her way.
Any response?
Yes, Your Honor. These questions are a base for later introducing an exhibit, and under Rule 404, it's to show a pattern, not to show to act in conformity. And it's also to eventually show plan and knowledge.
And what pattern is it attempting to show?
A pattern of acting out of emotional distress, for lack of a better word.
Any response?
Yes, Your Honor. The foundation has not been laid to establish a pattern, as the two acts are completely different. One of them involves acting out of rage and impulsively, and the second one involves plan and breaking into someone's house and eventually ending in a murder. These are two separate to establish a pattern.
Any further response?
Yes, Your Honor. It is also being showed as a practice of acting modus operandi under Rule 401B.
Can you elaborate on that?
Yes. It's to show that she's acting in a pattern of, like I said before, emotional distress. And although this is also offered to show plan and knowledge, there is a element of emotional distress under Avery Becker's accusation of murder, or under Avery Becker being accused of murder.
I'm going to sustain the objection. I don't find that it's been established that if it's attempting to show that emotional reaction, I do find that relates to a character trait, and that would not be proper for this particular instance. And I don't find that it relates enough to be a modus operandi. So I am sustaining the objection.
Thank you, Your Honor.
Your Honor, I move to strike any testimony that came out about the incident.
That's so stricken.
Okay. After Avery was kicked off the team, did any form of communication happen between the two of you?
Yes, Avery texted me asking if I could help get her back on the team.
And were you sure that the number you received the text message from was Avery Becker's number?
Yeah, my contact said so, and they also said so in the text.
And did you discuss the car incident at all?
Yeah, we did. I told her that Mr. Brackman was still pretty upset about it, and I didn't know if she'd be able to get back on the team.
And what did Avery say in response to this?
She said something along the lines of, if he didn't like that, wait till he sees what I do to his house.
And were you asked to show these text messages to the police?
I was. I sent them a screenshot.
Your Honor, permission to share screen with what has been marked as Exhibit 14.
You have that permission.
And what is Exhibit 14?
Those are the screenshots that I sent the police.
And did you take these pictures?
Yes, I did.
Do they accurately represent the pictures you took on that day?
Yes, they do.
Your Honor, I move to admit Exhibit 14 into evidence.
Any response from the defense?
Yes, Your Honor. I have multiple objections to this evidence. Would you like me to go through them all at once or one at a time?
Why don't you go through them all at once, please?
Of course, Your Honor. My first objection is hearsay. These are out-of-court statements being offered to prove the truth of the matter asserted that Avery Becker intended to break into Mr. Brackman's house, which is inadmissible pursuant to Rule 801. My second objection is more prejudicial than probative pursuant to Rule 403. These texts would, by only allowing this witness to test, excuse me, Your Honor, there has been no foundation laid that these texts really came from Avery Becker, and we only have this witness's word to tell the jury that they did in fact come from Avery Becker. This is substantially more prejudicial than probative, as the jury can only rely on this witness's word and they have no other foundation to back up her claims. Furthermore, I object to the authenticity, as once again, the foundation has not been laid to prove that these texts are in fact authentic. Furthermore, I object to best evidence under Rule 1002, as the original of these texts has not been presented by the prosecution. And finally, Your Honor, you just ruled on the improper character evidence of the vandalism of the car, and that same improper character evidence related to the vandalism of the car is involved in these texts. So I urge you to think about that carefully when deciding whether or not to allow these texts in. And finally, I object to lack of foundation, which is my overarching objection to these texts. There has been no foundation besides this witness's word laid to show that these are Avery Becker's texts. There has been no phone number provided or any picture of the contact information provided.
Can you share that again? Because I need to see the exact language on that text, if you wouldn't mind, Ms. Herman.
Yes, hold on 1 second.
And then your response whenever you're ready.
Okay, can I stop sharing or do you want me to keep
Oh, let me look real quick.
Okay. I can respond too.
If you can respond while it's up, that would be my preference. But if you need to take it off, just let me know.
Under Rule 901, this comes in under a witness with knowledge, as Avery and Alex were both on the mock trial team. And in response to your hearsay objection, these are statements from a party opponent. And I'm sorry, I don't remember all of your objections. Could you restate?
Well, let's start. Hearsay was the first one, and you just said this is a party opponent. So I'll go through them. Go ahead. That was the first one.
Okay. And then this comes in. Sorry.
Go ahead.
This comes in under 901 with a witness of knowledge, like I said, and that's all I remember so far.
All right. More prejudicial than probative.
Oh, okay. This is not more prejudicial than probative because under Rule 404, this shows plan, intent, and identity.
And then in terms of the best evidence.
Yes, hold on 1 second. So under Rule 1003, a duplicate is admissible to the same extent as the original.
And then lack of foundation would be the last one in terms of that this is from Avery Becker's phone.
Oh, I feel like I laid a proper foundation as I asked Alex, who is a witness with knowledge, again, if the phone number she received the text from was Avery Becker, and on the exhibit, it shows that the text message shows Avery saying it's identifying themselves and the contact says Avery Becker.
Any further response from the defense?
Yes, Your Honor. Pursuant to Rule 901B1, they need a witness with knowledge, and it is the defense's theory of the case that Avery Becker did not have her phone with her when these texts were sent and that these texts were faked. Therefore, this witness cannot have the knowledge to say for certain that Ms. Becker really did send these texts, meaning she cannot authenticate them. Pursuant to Rule 1003, a duplicate is admissible unless a genuine question has been raised about the original's authenticity. As a genuine question has been raised about the authenticity of the originals, it cannot come in under the duplicate under Rule 1003.
And just so I understand that objection, are you saying that the best evidence would be the phone itself?
Your Honor, I am arguing that these texts are not reliable or not accurately reflecting the information of the text between Avery and Alex, and therefore should not come in under the 1000 rules.
Thank you. All right, in terms of the hearsay objection, I am overruling the objection. I do find it as a statement against interest or an admission by a party opponent. In terms of the authenticity, the foundation has been laid in terms of the phone being that of Avery Becker, and therefore the text messages are found to have come from their phone. If there's other evidence that's presented, that would go towards the weight to be given to this evidence, not its admissibility. Further, in terms of the best evidence, these screenshots, the best evidence usually applies to a document there where something is written on this. The only other evidence that would exist as to these text messages would be the phone itself. And I don't find that provides any additional information that these copies are these copies would be sufficient in order for them to be able to be admitted into evidence. And I do find the foundation has been laid, and so therefore Exhibit 14 will be admitted into evidence.
Thank you, Your Honor. Okay. And who is Blair Rollins?
Blair Rollins used to go to CHS, I think. I didn't really know them that well.
Do you have a meaningful relationship with them at all?
Not at all.
Is it safe to assume that you would not have contacted Rollins during this case?
Yes, it is.
Lastly, why are you testifying against Avery Becker when you've mentioned your friendship?
Avery Becker is my best friend, and it pains me to have to do this, but if being a part of mock trial these past few years has taught me anything, it's that justice needs to prevail and the truth needs to come out, or else more murders like these will happen and more people will lose their friends, teachers, and role models. And that's just wrong. So I guess I'm testifying because it's the right thing to do.
Okay, no further questions, Your Honor.
Cross-examination.
Yes, Your Honor. Before I begin, may I have a moment to rearrange my virtual courtroom?
You may.
Can you hear and see me all right, Your Honor?
Yes.
Good afternoon, Ms. Fuentes. I'd like to talk to you about something you said on direct examination.
Okay.
You stated that you were friends with Avery, correct?
Yes.
However, there was also a rumor that you were rivals, wasn't there?
There was, but it's not true.
And you are aware that both Avery Becker and Taylor Perkins will testify that you weren't friends, aren't you?
I am, but that's just because it's the logical thing to do. They want to discredit me.
So you are aware that they will testify to that?
Sorry, could you repeat that?
So you are aware that they will testify to that?
I believe so, yes.
And despite your claim that you were very good friends, Avery still felt the need to introduce herself when she texted you?
I do that. I guess so, yes.
I'd like to talk to you a little bit about Blair Rollins. You attend Colorado High School, correct?
Yes, I do.
And Blair Rollins also went to Colorado High School?
Yes.
And you haven't seen Blair since before Mr. Brackman was murdered. Is that correct?
Could you repeat the question?
You haven't seen Blair since before Mr. Brackman was murdered. Would you agree with me on that?
That is not in my testimony, but I believe I have seen, or I would have seen Blair up until graduation.
Well, that's an important fact, but that's nowhere in your affidavit, is it?
No.
Now, you are aware that, or you said on direct that you were not friends with Blair Rollins, correct?
Correct.
However, you said hello and goodbye to each other in the hallways.
Every now and then.
And you were aware that Avery Becker and Taylor Perkins will testify that you were friends, aren't you?
I am.
And you knew that Mr. Brackman had defended Blair's father on a murder trial, didn't you?
Yes. Yes, I am.
Relevance?
Response from the defense.
Yes, Your Honor, this is extremely relevant as it is the defense's theory of the case that Blair Rollins is the alternate suspect in today's case. I am going into the bias and credibility of this witness.
Response from the prosecution.
I don't understand how whether or not Mr. Brackman was against Mr. Rollins, Blair Rollins' father is relevant at all to this case.
Any further response from the defense?
Yes, Your Honor, it is extremely relevant. As I will state in later questions, Mr. Brackman lost that murder trial where he was defending Blair Rollins' father. Blair Rollins has the motive to kill Mr. Brackman, which is the defense's theory of the case, making this extremely relevant to the trier of fact.
Based on the defense theory of alternative suspect, I find there's relevance and the objection is overruled.
Would you like me to ask that question again, Ms. Fuentes?
Yes, please.
No, you knew that Mr. Brackman had defended Blair Rollins' father on a murder charge, didn't you?
I wasn't exactly sure that it was Blair's father, but I knew that he was always doing things to help out students.
Mr. Brackman lost that case, didn't he?
I wasn't aware of that.
Well, let's talk a little bit about the mock trial team. Taylor Perkins was also on the team with you and Avery Becker, isn't that correct?
Yes, it is.
And you were at the Fry Shack on the night of March 5th, 2020, correct?
Yes.
And that was the night before Mr. Brackman was killed. Am I remembering that correctly?
Yes, you are.
Now, Avery Becker and Taylor Perkins were there together, weren't they?
Yes,
And they were best friends, weren't they?
I believe so.
Now, at the Fry Shack that night, you were playing on Avery's phone, weren't you?
I think I played a game.
So you had access to Avery's phone on March 5th of 2020?
Yes,
Avery is accusing you of stealing that phone, isn't she?
from what I've heard.
She is accusing you of giving it to the same Blair Rollins we were just discussing, isn't she?
Yes.
Well, I'd like to talk to you a little bit about the text messages that you brought up on direct. You're aware of our concerns that you faked those text messages, aren't you?
I am.
In those text messages, the person labeled as Avery threatened to trash Mr. Brackman's house. Isn't that correct?
That is correct.
After you received these texts, you didn't tell anyone about them, did you?
I didn't. I was genuinely worried for Avery, but I wasn't sure if she would actually do it.
So you didn't do it, did you?
I didn't.
Now, the police came to you, isn't that correct?
That is correct.
And that's when you told them about the text messages?
Yes.
Now, you didn't provide a picture of the contact information to show that it was Avery's phone number, did you?
I didn't. I wasn't asked to.
So the lead detective never asked you for that vital information?
No, I think my word should be enough.
And you also didn't provide the phone number associated with these texts, did you?
I did not.
Now, you didn't have your phone with you at the interview that day, did you?
No.
You offered to bring it in anyway?
I did, and I meant to.
But Detective Markowitz told you it was fine, right?
Yes.
So Detective Markowitz never had your phone, did she?
No, she didn't.
And you don't have this phone anymore, do you?
I don't. It got old, and I ended up trading it in for a new one.
So we can't analyze this phone?
No.
And since you never gave Detective Markowitz your phone, she was never able to download any information off of it?
That's true.
I have no further questions, Your Honor.
Any further redirect?
Yes, Your Honor. Why didn't you tell anybody about the text messages you received from Avery?
Well, I mean, Avery could get into some serious trouble if that wasn't real and if she was just mad. I didn't want to get her in any unneeded trouble.
Also, going back to Blair Rollins and the fact that Avery and Taylor will testify to you two being friends, is it normal for you to just be friendly to someone?
Yes, it is.
And would you say that people generally say hello or goodbye to just be friendly?
All the time.
No
I do it to people I don't know.
Sorry. No further questions, Your Honor.
Thank you. Prosecution may call your next witness.
Prosecution calls Kyle Kuzak to the stand. Please state your name and spell it for the court.
Hello, my name is Camille Denman, and I'm playing the role of Kyle Kuzak, K-U-Z-A-K.
And where do you work?
I work with the Denver Police Department.
And what is your occupation there?
I am a crime scene reconstruction investigator.
And what are your job duties?
I investigate complex crime scenes such as home invasions, burglaries, homicides, fatal accidents, etc.
And how long have you been investigating complex crime scenes?
I have 19 years of experience as a crime scene reconstruction investigator, and the most recent 3 years of my tenure have been with the Denver Police Department.
And are you a police officer?
I am not. I am a civilian employee with the Denver Police Department.
And do you have any certifications?
Yes, I'm certified by the Colorado Bureau of Investigation in crime scene reconstruction.
Your Honor, at this time, I tender this witness as an expert in the field of crime scene or certified crime scene reconstruction investigator under Colorado Rule 702.
Any objection to that from the defense?
No objection, Your Honor.
She is so designated.
Were you assigned to investigate the crime scene of the homicide that occurred at 444 Flower Street?
Yes, I was.
And did you visit this crime scene?
I did.
And what, if any, evidence did you review in this case?
I reviewed the Ring security camera videos and photos from the crime scene and evidence from interviews with suspects and witnesses.
What specific photographs did you view?
I viewed a lot of photographs for this crime scene. I viewed photographs of the victim from both inside and outside the house from various angles, a photo of a broken plate, scuff marks, blood spatter, and security footage from the Ring cameras.
And were the photos of the blood droplets and cast-offs intact when you viewed them?
They were, but it is my understanding that they were lost well after I had finished my investigation.
And after you reviewed these photographs, what did they reveal?
Yes, the photographs of the blood spatter revealed a clear chronology in which the victim was stabbed near the kitchen table and then proceeded towards the front door, where he removed the knife from his own back, where there was a knife and larger pools of blood, which indicated that he removed the knife from his own back and died there.
Your Honor, permission to share pictures of what's previously been marked as Exhibit 19.
You may share those.
Was there an autopsy created in this case?
Yes, there was.
And you were given access to this autopsy?
I was.
Who created the autopsy?
The autopsy was made by the City of Denver medical examiner, Mel Robbins.
And as a crime scene reconstruction investigator, do you rely upon this autopsy to reach your conclusion?
Yes, in many investigations, including this one, the review of an autopsy report is absolutely imperative.
Is this a fair and accurate representation or a fair and accurate copy of the autopsy report of Mackenzie Brackman?
Yes.
Your Honor, I move to admit Exhibit 19 into evidence.
Response from the defense.
I have no objection, Your Honor.
Exhibit 19 is admitted.
What was the cause of death of the victim?
The victim died of exsanguination after he bled out rapidly due to loss of blood from his aorta.
And was there any DNA or fingerprints found at the scene?
There was not, but that's to be expected with this type of investigation.
And were you able to reach any conclusions about what happened in this case?
Yes. Using the Ring security camera footage, I was able to conclude that an individual matching the approximate height and build of the defendant approached the house from the front and approached the front porch and tried the front door, and then eventually went around and entered the residence from the south side.
And what did you conclude happened as the perpetrator entered the home?
Well, it's obvious from the evidence and from the crime scene that the victim must have been alerted in some manner, either by his Ring security app, which provides notifications, or when he heard the door slide open, or hearing someone in his house. So in preparation, Mr. Mackenzie Brackman armed himself with a knife.
And what did you conclude happened next?
The victim and the perpetrator engaged in some sort of conflict, in a struggle, in which the perpetrator eventually got control of the knife and was able to reach around Mackenzie Brackman's shoulder and stab him in his shoulder, in his left shoulder.
Thank you. No further questions.
Cross-examination?
Yes, Your Honor, but before I begin, may I have a brief moment to rearrange my virtual courtroom?
You may.
Good afternoon, Ms. Kuzak. I'd like to talk about a few things you mentioned during direct examination. You stated that Avery Becker matches the height and build of the perpetrator seen in the Ring doorbell videos. Is this correct?
That is correct.
However, nowhere in your statement do you specifically state the height of Avery Becker, yes or no?
No, I do not.
In fact, you don't even know the victim, Mr. Brackman's height, do you?
It is not in my statement.
And you never measured Mr. Brackman's body on the scene, yes or no?
I did not. I imagine it is reported in the autopsy report, but I don't remember.
And in fact, nowhere in the autopsy report is there a specific height from Mr. Brackman.
There's not a height. In the autopsy report?
Yes, nowhere in the autopsy report is there a specific height stated for Mr. Brackman.
I do not know.
So it is your testimony today that you relied on the autopsy report to come about your conclusions, and you don't know if Mr. Brackman's height is in the autopsy report. Did I hear that right?
I relied on different details from the autopsy report. The height was not relevant.
However, you also stated in direct examination that part of your theory is that the perpetrator hugged Mr. Brackman and stabbed him in the scapula. Is that correct?
Yes, that is correct.
So because you didn't think height was relevant, you don't think it's relevant that a shorter perpetrator could reach over and stab Mr. Brackman in the scapula?
I did not keep track of the heights of the perpetrator and the victim, but it is completely obvious from my investigation that what happened was that the perpetrator reached around and stabbed him in the shoulder from a bear hug type position.
So Ms. Kuzak, if I hear you correctly, you didn't think height was relevant in today's investigation. Therefore, you never offered conclusions about a perpetrator being shorter than the victim and stabbing the victim over the shoulder. Yes or no?
No.
Let's talk about some of your other conclusions. You agree with Professor Van Owen that the knife from the knife block is a different brand from the other knives found in the knife block, correct?
That is correct.
And just to be clear, during direct examination, you stated that some of the photographs were corrupted.
Yes, that is correct.
And some of the photographs from the blood droplets and cast off were lost, correct?
Yes, they were. They were lost well after my investigation and it did not hinder it in any way.
Exactly. They were lost after your investigation. So Professor Van Owen didn't get to view these exhibits, correct?
That is correct.
Now, I would like to talk about the alternate suspect in today's case. You were present for Detective Markowitz's testimony.
I was.
And you heard her when she stated that she had never heard the name Blair Rollins before, correct?
That is correct.
But you would agree with me that Blair Rollins is an alternate suspect in today's case, yes or no?
My job description does not entail determining a suspect.
So it is your statement today that you are not aware of Blair Rollins being a suspect?
Determining a suspect is not relevant to my job.
Ms. Kuzak, you prepared a CSR witness tracking sheet, correct? It would be Exhibit 17?
Yes, I did.
Your Honor, at this time, I ask for permission for a defense trial technician to display its Exhibit 17 on the screen.
You may do so.
Now, Ms. Kuzak, you would agree with me that on the fourth box where it says summary of information and evidence, you would agree that Blair Rollins is described as a suspect, S3. If my defense trial technician could please hover over that section.
Yes.
Okay. Your Honor, at this time, I move to admit Exhibit 17 into evidence.
Any objection from the prosecution?
No, Your Honor.
Exhibit 17 is admitted.
Ms. Kuzak, so you would agree with me that you wrote the CSR witness tracking sheet?
Yes, I did, but I used this tracking sheet for the organization of objective evidence, and my actual job entails a more scientific reconstruction of the crime scene and is not dependent on objective evidence obtained from interviews.
Ms. Kuzak, I understand that is your opinion. However, because you wrote this exhibit, you are therefore aware that Blair Rollins, as stated, where the cursor is a suspect in today's case, or initially was a suspect for the prosecution. Yes or no?
I would agree.
Now, Blair Rollins wasn't ever contacted by law enforcement, correct?
Not to my knowledge. My job description would not have involved that, so I don't know.
So you would agree with me that Blair Rollins up on the screen is described as an unlocated party?
I agree, that's what it says.
Thank you, defense trial technician. You may stop displaying that. Now, I want to talk about the alibi. You would agree with me that Taylor Perkins testified that she was Avery Becker's alibi, correct?
I did not hear Taylor Perkins testify to that.
But you would agree with me that you are aware that Taylor Perkins testified to this, yes or no?
Yes, the location of the defendant at the time, my investigation was not relevant to Avery Becker and Taylor Perkins at this point.
Your Honor, once again, permission for defense trial technician to display Exhibit 17 on the screen.
You may.
So you would agree with me that within this exhibit, and may the record reflect I have my own personal copy of Exhibit 17 in hand. You would agree with me that this exhibit, the one you wrote, states that whereabouts on day preceding and day of homicide described a text and phone exchange with Perkins on AM/PM of March 6, 2020, familiar with suspect 2 and suspect 3, expressed remorse about prior involvement with the victim on CHS team. Yes or no?
I agree that is what it says in the exhibit. However, I did not investigate the cell phones as that is out of my expertise and not relevant to crime scene reconstruction.
Ms. Kuzak, I understand that is outside the scope of your expertise. However, you are aware that Taylor Perkins corroborated that she was with Avery Becker on the day in question based on the exhibit you wrote.
Yes, that is what it said in my organization of objective evidence.
Therefore, you are aware of this evidence, yes or no?
I am aware of it.
Thank you, Your Honor. I have no further cross-examination.
Any redirect?
Yes, Your Honor. Ms. Kuzak, with accordance to the knife and the knife block, was there a specific knife that was fitting the knife block that was meant to be there?
Yes, the knife which was missing from the knife block was a large chef's knife, as was the knife ultimately recovered from the body.
And does your job entail anything to do with determining or finding the heights of people related to the case?
It does not. My job, I follow a 5-step process, which involves nothing in regards to determining the heights or determining suspects. My job is simply to reconstruct what happened.
No further questions, Your Honor.
Thank you. Any further witnesses for the prosecution?
No,
Yes,
Your Honor.
Your Honor. Oh,
No, you're ready for my next question. First witness for the defense.
Yes, Your Honor, but before I begin, may I have a brief moment to rearrange my virtual courtroom?
Yes.
The defense calls Professor Blake Van Owen to the stand.
Please state your name, including your scoring name for the record.
My real name is Caitlin Brennan, Brennan, and I am Professor Blake Van Owen.
You may proceed.
Professor Van Owen, how are you involved in today's case?
I'm here to discuss the investigation into the death of Mackenzie Brackman, specifically the defendant's alibi, an alternate suspect, and the awful investigation that led to overlooking both of those two crucial aspects.
Can you tell the jury a little bit about your qualifications to conduct an investigation of this nature?
Of course. I earned my master's degree in criminal justice from Ashford University. I started my career as a police officer with the Aurora Police Department. And since then, I've worked as a private investigator, and for 5 years now, I've lectured on police practices and social justice at the University of Colorado, Denver.
Have you ever testified as an expert in court?
Yes, I've testified as an expert in over 100 cases. Specifically, I've testified in the U.S. District Courts of Colorado and Kansas and Arizona, and U.S. State Courts of Colorado, Nebraska, New Mexico, and Wyoming.
What areas of expertise have you been qualified under?
I've been qualified under many areas of expertise, but the ones that pertain most closely to this case are general police practices, the general investigation techniques, forensic evidence techniques, cell tower analysis, and scene reconstruction.
Your Honor, at this time, I ask that the court tender Professor Blake Van Owen as an expert in general police investigation with an emphasis in cell tower analysis, police procedures, forensic evidence, and crime scene reconstruction.
Any objection from the prosecution?
I think our attorney is not here.
Oh. Let's see if I've got someone else. I didn't lose anybody. I have the same number of people. That's why I didn't notice that. What is the name of that attorney?
Oh, sorry. Sorry,
Oh,
it like lagged out and I couldn't see anything.
no problem.
My
There we
apologies.
got you back. That's okay.
No objection.
All right, thank you. She is so qualified.
Professor Van Owen, you mentioned that there was an alibi, an alternate suspect, and an awful investigation. I first want to talk about the awful investigation. Can you explain what exactly you mean by this?
Of course. Many aspects of the prosecution's investigation were either rushed or designed to only consider evidence that fit their biased perspective. For example, we have the way the victim died, the murder weapon or the knife itself, and all of the technology involved in today's case, including the call detail records and the Ring doorbell videos.
Let's start with the conclusions about how the victim died. Tell us more about those.
Well, the prosecution asserts that the victim initially possessed the knife, which was wrestled away from him by the intruder, who then used it to stab the victim in the back. Now, this rests on a few assumptions. Assumptions about the scuff marks found by the back door, assumptions about the broken plate, assumptions about a supposedly overturned chair, and assumptions again about the murder weapon or the knife itself.
Can you elaborate on these assumptions?
Of course. Now, I'll start with the scuff marks. First off, scuff marks can't be carbon dated. This means that they could have come from the crime, as the prosecution promptly assumed, but they also could have come from a week before, a year before, or possibly even before the home even belonged to Mr. Brackman. Now, the broken plate and supposedly overturned chair are consistent with a number of different plausible explanations.
Do you have any other concerns with the crime scene itself?
I do. The knife that was found by the victim, the murder weapon, does not match any of the other knives that can be found in the Brackman residence. Now, additionally, the style and design of the knife, as well as the wound it caused, are not consistent with the prosecution's explanation of what happened. I even prepared an exhibit to help explain this.
Your Honor, permission for defense trial technician to display Exhibit 21.
You may.
Professor Van Owen, do you recognize this exhibit?
I do. This is the exhibit I was just talking about. It shows how a knife of this nature would typically be held.
Your Honor, at this time, I move to admit Exhibit 21 into evidence and subsequently publish it to the jury.
Any objection from the prosecution?
Yes, Your Honor. We feel this has zero relevance as this knife is not visibly similar in any way to the knife that was used in the weapon. In the murder.
Your Honor, may I respond?
You may.
Pursuant to Rule 401, this is relevant as it tends to go to the trier of fact and how the stabbing of the victim actually occurred, which is extremely relevant in today's case. It is relevant to determine how the stabbing occurred and in what position it occurred. And this is part of the defense theory, which defense has an opportunity to put their case and present competing theories, Your Honor.
Can you respond to that? I think the objection was that this is not a similar knife. I think that was the objection. Is that correct, Mr. Newman?
Yes, Your Honor.
Right. Can you respond to that?
Yes, Your Honor. As to the knife, as Professor Blake Van Owen explained, the knife in question, the brand or the type of knife seen in the photograph isn't actually being used to determine whether or not it's the same knife, simply the way the knife itself was held.
Any further response?
Yes, I do not believe that you can fairly show the way the knife was held without using an identical knife to the original, or to the one that was likely used to kill Mackenzie Brackman. I'm going to admit Exhibit 21. I find that for the reasons stated by the defense, that it is any objections as made by the prosecution goes to the weight in terms of the brand and whether or not it's identical changes anything in terms of the witness's opinions. And so I'm going to allow the Exhibit 21 is admitted.
Now, Professor Van Owen, using Exhibit 21, can you explain your concerns with the prosecution's theory?
Well, as you can see in this exhibit, and it's even more pronounced in the photos of the actual knife itself, the top part of the handle is straight, whereas the bottom part of the handle is a little bit curved, where the fingers go around it. Therefore, when you're, say, chopping food, your fingers would be pointed down while curled around the curved part of the knife, and the blade would be pointed down. So now if the knife is held in a more overhead fashion, like this shows, the fingers would still be wrapped around the curved part of the knife and pointing in the same direction as the blade. This is the most comfortable way a knife of this nature would be held. And if it was indeed held this way, which is most likely, the wound it caused would have been much different if we were to go with the prosecution's theory.
Thank you, defense trial technician. You may stop displaying Exhibit 21. Professor Van Owen, were there any other concerns with how the victim passed away?
Yes. So the victim had a Ring doorbell system. This just means that he had cameras installed around his house that he was monitoring from his phone. Now, we don't know if his notifications on the system were turned on or off, and that's because Detective Markowitz never looked at the actual information on the account to see whether or not this was the case. Now, even if these notifications were turned on, there's nothing to say that the victim had his phone nearby, and even if the phone was nearby, there's nothing to say that he saw or acted on these notifications.
Now, based on this evidence, and in your expert opinion, is it possible that Avery Becker could have been involved in this crime?
No, none of the evidence conclusively links Avery Becker to the scene of the crime.
Now, I want to talk about the alibi you mentioned earlier. Who's the alibi in today's case?
Well, Taylor Perkins and Avery Becker were together on the day in question at the mall, looking for Avery Becker's lost phone.
But if you do recall, Professor, the prosecution mentioned that Avery Becker was actually in the vicinity of the victim's residence. So how can she have an alibi?
Well, in this case, they were looking at the call detail records, which examine the Avery Becker's phone. Now, if they were looking at Avery Becker's phone, which we've already established was lost, then they can't have been looking at Avery Becker herself. Now, in addition, all of this information all of the call detail records were only obtained for the day in question, not the day before the day in question. So we can't be sure where the phone was beforehand and whether or not the phone was actually taken.
Did you do anything to verify that Avery Becker was actually at the mall?
I did. I looked at call detail records from both Avery Becker's phone and Taylor Perkins' phone. Now, it shows that from all of the calls received by Avery Becker's phone, corresponding calls and texts were sent from Taylor Perkins' phone. And this backs up their story that they were calling and texting Avery's phone to try and find it while they were at the mall. Now, in addition, all of the calls and texts sent from Taylor Perkins' phone were sent from the antenna that covers the area around the mall.
So, based on this evidence and in your expert opinion, is it possible for Avery Becker to have been at the scene of the homicide?
Well, since we know that Avery Becker was at the mall on the day in question, and it's impossible for someone to be in two places at once, it's therefore impossible for her to have been at the scene of the crime on the day in question.
Objection assumes facts, not in evidence. It has not been verified that Avery was at the mall on the day in question.
Response from the defense.
Your Honor, this is not assuming facts and evidence. This is Professor Van Owen's conclusion based upon all of the CDR records that she analyzed. Therefore, she can rashly come upon this conclusion and offer it as part of defense theory.
Any further response from the prosecution?
No, Your Honor, we stand by our objection.
I'm going to allow it as part of her opinion. I do note that I've not heard evidence that evidence has not been admitted in terms of the whereabouts of Ms. Becker. And so therefore, I'm going to allow the testimony as part of the opinion evidence of Professor Van Owen.
Yes, Your Honor. Now, lastly, I want to talk about the alternate suspect in today's case. If Avery Becker couldn't have committed this crime, then who could have?
Her name is Blair Rollins. She's a student at Colorado High School, or CHS, with Avery Becker, Taylor Perkins, and Alex Cifuentes. She's about the same size and build as Avery Becker from what I've seen in the CHS yearbooks, which is therefore about the same size and build as the person seen in the Ring doorbell videos.
Is there any evidence that Blair Rollins has a motive to go after Mr. Brackman?
Yes, actually. Mr. Brackman attempted to defend Blair Rollins' father against a murder charge. Now, unfortunately, Mr. Rollins was ultimately convicted and sent to jail. And at the sentencing hearing, which Blair Rollins was present for, Mr. Rollins threatened harm on Mr. Brackman.
Do you know where Blair Rollins is today?
I don't. I conducted extensive research in my attempts to locate Blair Rollins, but to no avail. She simply disappeared after the day in question.
Based on this evidence, and in your expert opinion, is it possible for an alternate suspect to be involved in this crime?
Because Avery Becker had an alibi and the prosecution conducted an awful investigation, it's entirely possible that there was an alternate suspect that could have committed this crime.
Thank you, Professor Van Owen. Thank you, Your Honor. I have no further direct examination.
Thank you. Cross-examination, please.
Yes, Your Honor. You talked extensively about how you felt the prosecution's investigation was awful, correct?
That's correct.
And one of your major gripes is that they never checked the alibi of Avery Becker, correct?
That's correct.
You did not check the alibi of Avery Becker either, correct?
I believe I just talked extensively about the alibi of Avery Becker and how the call detail records back that up.
You did not use Taylor Perkins' phone to confirm the alibi that they were at the mall, correct?
I used all of the call detail records from Taylor Perkins' phone.
You did not. Taylor Perkins offered to both the police and you to use her phone to see the GPS data, correct?
I don't believe she ever did, but the call detail records are perfectly sufficient.
And okay. And if you had the blood spatter photos, might that have changed your conclusion?
It may have, however, all of these photos were corrupted, which again is a big red flag as there should have been multiple copies of these photos in the first place.
But is it possible for that to have changed your conclusion?
It is possible, but again, I had the descriptions of the blood splatter from Kyle Kuzak, so it likely would not have changed my position.
Okay. And then, but might your investigation be faulty based on the missing evidence?
If anything's faulty, it's the prosecution's investigation and the fact that there is missing evidence in the first place.
And then in addition, well, Kuzak opined that there was blood on the ceiling by the door. Did you use that in your did you take that into account when thinking about your theory of the case?
As I stated, I had the descriptions of all of the blood splatter, and I used that when coming to my conclusions. It would not have changed my position if I had seen these photos rather than hearing about them. It just shows the failings of the prosecution's investigation.
Okay. And then in addition, how much are you being paid for this case to testify in this case?
I believe it's $225 an hour, which is standard for a private investigator like myself.
And are you being paid any extra to testify?
I am, again, standard procedure for a private investigator like myself.
Objection,
And how
Your
much
Honor,
extra is that?
relevance.
Response.
I am attempting to show the bias and credibility of the witness and a lack of credibility from this witness.
Any further response to that?
Yes, Your Honor. I understand that cross-examination is used to go into the bias and credibility of a witness. However, talking about the line of questioning about how much professor is being paid or an hour or her standard rates has no relevance to the trier of fact in today's case.
I'm sorry, did you want to respond for?
Yeah, I feel that it does affect the trier of fact, as it can shape the way it can affect the weight of the testimony that Professor Van Owen is providing.
I do find that it goes towards the weight, that a relevant inquiry is the compensation received by the witness. And so I will overrule the objection. I want to make a quick record too. Someone asked me a question on the chat as to what this witness was qualified in. I responded, and I may have responded to the wrong person. And so I wanted to respond to everybody because to make sure that that information is provided. And so the answer that I had given to the question of what this witness was qualified in as an expert is general police procedure, the cell tower, crime scene reconstruction, and forensic evidence. So I apologize for answering the chat incorrectly and wanted to have that out there. So I'm sorry, continue with your questioning from the defense. I'm sorry,
And
you're still on yours, I'm sorry.
You have not testified for the prosecution since you left the police department, correct?
I have not. The prosecution often employs law enforcement members, and they don't pay private investigators like myself.
But you have only ever testified for the defense, correct?
And that's correct, as I just stated.
Okay. Thank you, Your Honor. No further questions.
Anything further from the defense?
No redirect, Your Honor.
Thank you. Thank you, Professor. Next witness from the defense.
Yes, Your Honor. The defense calls Taylor Perkins to the stand.
Please state your name, including your scoring name for the record.
My name is Annika Buchin, Bucchin, and I am Taylor Perkins.
Whenever you're ready.
Yes, Your Honor. And before I begin, I'd just like to confirm that you can see and hear me all right?
Yes.
Good afternoon, Ms. Perkins. Would you please introduce yourself to the jury?
Hi, my name is Taylor Perkins. I'm a freshman at CU Boulder. Go Buffs. And last year I was on the CHS mock trial team.
Now, Ms. Perkins, I'd like to start off by talking to you a little bit about Avery Becker's alibi. Were you with Ms. Becker on March 6, 2020?
Oh yeah, I was with her the whole day. We were looking for her phone. It was stolen the night before, so we ditched school the next day to look for it.
Why do you think her phone was stolen?
Well, the day before, we went to the Fry Shack together, and Avery was pretty upset, and so she left her phone on the table after interacting with some old mock trial teammates. So she left her phone on the table and got up, and then by the time she came back, we just left. It wasn't until later that we realized that the phone was stolen.
And what time did you go to the Fry Shack?
On the day of March 6th, it must have been sometime in the afternoon.
Why's that?
Well, for one, we spent the whole day looking for her phone, so it was pretty late in the day by the time that we got there. But also, we went to the Fry Shack specifically for the afternoon shift change. Avery and I were hoping that maybe somebody who was working from the night before would be working there again and could tell us if they had seen the phone.
Did you and Ms. Becker ever find Ms. Becker's cell phone?
No, we never did.
Now, I'd like to talk to you a little bit about the investigation in today's case. There has been some evidence that the detectives failed to contact key witnesses. Did the police ever contact you?
No, they never did. I haven't heard a thing from the police. You know, come to think of it, the police conducted a pretty awful investigation considering I was with Avery the whole day and they never bothered to reach out to me.
Objection, speculation.
Any response from the defense?
Yes, Your Honor. May I ask opposing counsel to clarify as to what section of the testimony they're objecting speculation?
Yes, I am objecting to her answer, and I don't think she's qualified to answer whether or not the case or the investigation was awful. So,
may I respond, Your Honor?
You may.
Your Honor, this is not speculation. The witness has just testified that the police never contacted her. This is rationally based on her perceptions and observations. Furthermore, she is qualified to talk about this as this is not an expert opinion. There is nothing inherently technical about this opinion that cannot be opined to by a lay witness.
I'm going to sustain the objection. I do find classification as it relates to whether or not the investigation was done properly would require an expert opinion and so forth. Therefore, the objection sustained.
Yes, Your Honor. Were you finished with your response, Ms. Perkins?
Yeah, I was. I just said that the police didn't contact me even though I was with Avery the whole day in question.
So did the police ever ask to see your phone?
No, they never did.
Now, lastly, I'd like to talk a little bit about the alternate suspect in today's case, Blair Rollins. Did you know Miss Rollins?
Yeah, Blair and I went to high school together. I'm a year older than her, so she should be a senior this year. But I haven't seen her in a while.
Well, when was the last time you saw Miss Rollins?
It must have been sometime last year, back when we were both in school together, but not since all of this happened.
Just to clarify, have you seen Blair Rollins since March 6, 2020?
No, I haven't. I don't know of anyone that's heard or seen from Blair since she went missing that day of March 6th.
And did Miss Rollins have any friends at Colorado High School?
She did, yeah. I saw her a lot with Alex Cifuentes. They were pretty close.
Lastly, Ms. Perkins, does the fact that you're friends with Avery Becker have any impact on what you've testified to today?
Absolutely not. Look, Avery and I are friends, no doubt, but that doesn't impact anything that I've said today. I was with Avery on the day in question.
Thank you, Your Honor. I have no further questions at this time.
Thank you. One moment. I think I lost somebody. Anna Carrington is trying to get back in. She's on one of the teams. Is that right?
Yes, Your Honor.
All right. I'm going to let her
She's on the
back in.
defense team.
Perfect. She's back in. All right. Prosecution, you may cross-examine.
Yes, Your Honor. You say that Avery and Alex were not friends, correct?
No, they weren't.
And Avery would you say that Avery came to mock trial practice pretty unprepared?
Sometimes, I mean, Avery could be unprepared sometimes, but that doesn't really deter from the fact that Avery was talented at mock trial. So although that's true, it doesn't really have any impact on her ability to produce great results.
So she made things up on the go and exaggerated?
At times, yeah.
And even with making things up on the go and going off script, Avery still won many awards, correct?
Absolutely. Like I said, she had a true talent for mock trial.
So it's fair to say that Avery was good at improvising and making things up on the fly.
Yeah, like I just said, in mock trial, it was one of her gifts.
Okay, moving on. You were a senior and mock trial was something you'd done for years, correct?
Yeah.
But you did not mind giving up your spot for Avery, correct?
That's true. Although I did mock trial for years, I wasn't as passionate about it as she was. It wasn't that big of a deal for me to give it up for her.
And you did not mind ditching school on March 6th for Avery to help find her phone, correct?
No, I didn't mind. We had taken our lit quiz earlier that week, so we didn't really have that much school in general. So again, wasn't a big deal.
Would you say that Avery is your best friend?
Yeah.
And you wouldn't want anything to happen to them, correct?
I'm not quite sure what you're asking.
Well, you wouldn't want them to be convicted of anything and be in jail for the rest of their life.
No, specifically because Avery was with me on the day in question. I wouldn't want Avery to go to jail for something she didn't do.
And you also say that Avery never left their phone and was basically attached to it, correct?
Yeah, it was like a third kidney to her.
And Avery left it and didn't remember that they left it until the day of March 6th when Mr. Brackman was murdered, correct?
Yeah, and she left it on March 5th, actually, and then she didn't remember on March 6th, but that speaks to how overwhelmed and upset that she was. I mean, the fact that she left her phone on the table is really clear that she was upset and wasn't thinking clearly. It's not like Avery to just leave her phone somewhere.
And it took you a while to figure out that Avery's phone was missing, correct?
Well, the next morning I was texting her and she wasn't responding, so when she picked me up for school that day, that's when we talked about it.
So you ditched school to look for the phone, correct?
Yeah, that's right.
And you were gone for the whole day?
Yes.
The day that Mr. Brackman was murdered?
Yes.
Okay, no further questions, Your Honor.
Redirect?
Before I begin, Your Honor, may I inquire as to how much time I have remaining?
Yes,
go ahead. You have 13 minutes and 52 seconds. No, you have 11 minutes and 18 seconds. My bad.
Briefly, Your Honor, may I have a moment to rearrange my virtual courtroom?
Yes.
Ms. Perkins, could Avery Becker have committed this crime?
Again, absolutely not. I was with Avery the whole day. I think I would know if she just up and killed our mock trial coach. She was with me the whole day. We were looking for her phone. I don't know how many times I can say that.
Thank you, Your Honor. I have no further questions.
Thank you. Next witness for the defense.
The defense calls Avery Becker to the stand.
All right, please state your name, including your scoring name for the record.
My name is Hannah Feeney, but I'm Avery Becker.
Thank you.
Well, before I begin, can you hear and see me all right, Your Honor?
Yes.
Now, Ms. Becker, could you tell the jury a little bit about yourself?
Well, I would have been a freshman in college this year, but I've had to put my life on hold for something I didn't do. And I just want to look y'all in the eyes and tell you the truth.
Have you been present for the testimony from all the witnesses today, Ms. Becker?
Yes, I have.
And did you kill Mr. Brackman?
No, I'm not a murderer. He was my mock trial coach, and I never could have done anything to hurt him.
Let's discuss the prosecution's investigation in today's case. We just heard that Taylor Perkins was never interviewed by the police. Do you know of any of your friends who were?
No, not that I know of.
Were your parents ever interviewed by the police?
Not that I know of.
Well, did the police ever search your house for evidence?
No, but I wish they would have. Detective Markowitz could have seen I didn't have my phone or anything else related to this crime.
Earlier, we heard that the murderer was caught on camera by Mr. Blackman's Ring doorbell. Ms. Becker, is that you in the video?
No, like that attorney said earlier, that's not me in the video. I was at the mall with Taylor all day, and it's not like I can be in two places at once, but it easily could have been Blair Rollins.
Have you ever been to Mr. Brackman's house?
No, I don't even know where he lived.
Well, let's discuss the prosecution's evidence against you in today's case. Did you send the text messages to Alex Cifuentes like the prosecution claims?
No. Even if you believe Alex about us being best friends, no one takes their best friend like that. I don't know about Alex, but I don't text my friends, "Hi, Alex, it's Avery." And plus, they just don't make any sense.
Well, what do you mean by that?
Well, when I saw him earlier, I didn't see any timestamps or dates or anything. So this all has to be one conversation. And how can someone go from trying to get back on a team to threatening to trash the house of the coach of that same team in a split second? It just doesn't make sense.
So would you ever threaten to trash Mr. Brackman's house or anyone else's house for that matter?
No. After I got kicked off the team, I just wanted to apologize and finish up my senior year in mock trial. I even went to Mr. Brackman's office to try to apologize, but Blair Rollins killed him before I ever got the chance to say I'm sorry.
Now, earlier we heard that Alex Cifuentes said you were best friends. Were you?
No. We were on the same team in mock trial, but Alex and I never really got along. He was always going after the roles that I got, and with me gone, he might have actually gotten a Best Attorney award. I wouldn't be surprised if Alex wanted to keep me off the team because of that.
So did you send a text to Alex Cifuentes asking for help?
One moment. Give an objection.
Objection. Answer calls for speculation. She is assuming that Blair Rollins killed Mr. Brackman.
Any response from the defense?
Yes, Your Honor. First, may I clarify that this objection is to a few questions before?
Yeah. Which answer are you objecting to? Mr. Hollis.
The previous question before the one we were just talking about.
All right. And so based on that clarification, do you have any response?
Yes, Your Honor, this is not speculation pursuant to Rule 701. This can be rationally based on the witness's perceptions and observations. She has already testified that she has been present for all the witnesses today, and she has heard all the testimony that has come forth about Blair Rollins. Furthermore, the witness did not state for certain that Blair Rollins committed the crime. She just said it could have been Blair Rollins.
Any further response from the prosecution?
It was not in evidence that it was Blair.
I am sustaining the objection. It's a little late, but I am sustaining the objection. The statement was that Blair Rollins was the one that did it, and that is improper speculation, and so therefore the objection is sustained and the answer stricken.
Thank you, Your Honor.
So did you send a text to Ms. Cifuentes asking for help getting back on the team?
Well, no. I didn't think he liked me, so I didn't think he'd help. I didn't even think to reach out to Alex, if I'm being honest.
Now, is it possible that you could have had the time to commit this crime without Taylor Perkins knowing?
No. We were at the mall together all day looking for my phone, like she just said.
Now, since we just heard from Ms. Perkins, we'll skip going over all the details again, but to confirm, did you ever find your phone?
No, and over the past year, I kept thinking maybe Alex took it.
Oh, when could Ms. Fuentes have taken your phone?
It was the day before, and Taylor and I were at the Fry Shack when Alex and some of the other mock kids came in. I got a little mad because I'd just been kicked off the mock trial team. And
Is there an objection?
Objection, speculation.
And which part of the answer are you objecting to?
Alex stole his phone.
Response from the defense.
Yes, Your Honor, the witness is laying the foundation for her answer at this very moment, and it can be rationally based on her perceptions and observations. She is the owner of the phone. She knows when the last time she had it was, and she knows when it went missing. Therefore, she can rationally make a guess as to who took it or when it went missing.
I'm going to allow the answer to continue. I do find that the statements at this point have not been that that was what happened, but the foundation is being laid. The objection is overruled.
Ms. Becker, could you finish your answer?
no, so the mock kids came in and I got mad because I'd just been kicked off the team. And so I left my phone on the table and I went to the bathroom to cool down. When I came out, I just left. There was plenty of time for Alex to take it.
Let's discuss Blair Rollins. Do you know Blair?
Kind of. We were in the same grade at school, but we weren't real close.
Do you think you could describe what Blair was like for the jury?
Well, everybody knew that Blair hated Coach Brackman.
Do you know why?
Brackman was a criminal defense attorney, and from what I heard, he represented Blair's dad on a murder charge, but he lost the case and Blair's dad went to jail.
Could you describe the height and build of Blair Rollins?
We're about the same height and build. Anyone seeing the two of us walking away could confuse us.
Objection?
Objection, hearsay.
All right. And I do think I've lost someone. I am one person down. And so I want to make sure who I am missing before we go any further. If you could stop the time. Go ahead.
That, I believe, is one of our attorneys, Madeline. Her computer has died.
Okay. Do we want to stop and wait for her to get back on? Let's see, hang on. No.
I could go and try and confer with her and see if there's an alternative.
Try that. I know there's an option too, that if she just needs to call in, so she can be in just the like on her phone, just the hearing part of it, she can do that as well if she can't get her computer to work.
Your Honor, she is going to another classroom to listen to it with another one of our team members.
Okay. And so should we wait till we know she's there? If you could let me know, and then we'll get started back up again.
Actually, Your Honor, she's found a charger and she's going to try to get back onto the Zoom now.
Okay. And so we're waiting for her then to do that. Is that correct?
Yes, Your Honor.
Okay. Oh, here she is. All right, we've got Ms. Herman back. Mr. Hollis, you were making an objection and the objection was speculation. And so can you please clarify which part of the answer you were objecting to?
I actually objected hearsay and it was.
I'm sorry. Go ahead.
One second. I I take back my objection. I'm sorry.
All right, that's fine. Continue with your direct examination.
So were you finished with your answer, Ms. Becker?
No, I'm sorry. Could you repeat the question?
Of course. Do you know why Blair hated Mr. Brackman?
Yeah, like I was saying, Mr. Brackman lost the case and got Blair's dad sent to jail.
And could you describe the height and build of Blair Rollins?
Like I said, we're about the same height and build.
Yes, there's an objection.
Relating to Dad, I would like to object over hearsay.
All right, response from the defense.
Your Honor, is the objection to the question about what she heard about Blair Rollins?
Correct.
Your Honor, we are not offering this to prove the truth of the matter asserted pursuant to Rule 801. We are not offering this to prove that Mr. Brackman did in fact defend Blair Rollins' father. Instead, we are offering it to show that there was another witness, there was another suspect with motive that was never investigated.
Response from prosecution.
I stand by my objection.
I am going to sustain the objection. I do find that whether or not that it is being offered for the truth of the matter, the truth that that was the motive for for Ms. Rollins is as the alternate suspect. So the objection sustained.
Oh, Ms. Becker, when was the last time you saw Blair Rollins?
It had to have been sometime before all this went down, but I can't be sure exactly when it was because I only really saw her in the hallways at school.
If you weren't friends with Blair, how is it possible that she could have had your phone at the crime scene?
Well, Blair and Alex were best friends.
Now, a few moments ago, you mentioned that you haven't seen Blair since before Mr. Brackman was killed. Do you know of anyone who has?
No, not that I know of.
Thank you, Ms. Becker. Thank you, Your Honor. I have no further questions.
Thank you. Cross-examination.
Yes, Your Honor. You and Mr. Brackman had numerous conflicts in mock trial, didn't you?
Yeah, it was really dumb and I regret every second of it.
And you believe that Mr. Brackman never gave you credit for anything you did, right?
No, that was one of the dumb things we disagreed about.
And he bumped you off the A team to the B team, didn't he?
That's right.
Objection, Your Honor. May I be heard?
Yes.
This question goes to an incident before Ms. Becker was back on the A team, which is what she was kicked off of. Finally, it has no relevance to today's case as it does not help the trier of fact come to any conclusions about anything.
Response, Mr. Hollis.
I am showing the relationship between Mr. Brackman and Avery Becker.
Any further response?
Yes, Your Honor. This testimony is from an incident before any of this took place, and it has no relevance to today's case.
I'm going to overrule the objection. I do find that it is part of the context of the relationship, and I find there's some relevance there, so the objection's overruled.
Thank you, Your Honor. You managed to get back onto the A team, correct?
Yeah, I did.
But your friend Taylor had to sacrifice their place for you to stay on the A team, didn't they?
She offered to. It was real nice of her.
And even after your success and awards, he didn't congratulate you, did he?
No, like I said, our disagreements were dumb.
So you then proceeded to vandalize his car, correct?
Objection, Your Honor. May I be heard?
You may.
As I objected to this testimony on Alex Cifuentes' direct, and it was kept out. Therefore, this evidence should not be allowed back in.
Response from the prosecution.
May I confer with my counsel?
You may.
I am ready to respond.
You may.
Your Honor. I believe that it is further showing the relationship between Brackman and Avery, and also shows the history of the impulsive behavior against Mr. Brackman.
Response from the defense.
Yes, Your Honor. While opposing counsel may be using this for something that he thinks is important, it is still improper character evidence pursuant to Rule 404A, as it is being offered to show that Avery Becker acted in accordance with a character trait, as well as acted in accordance with a prior bad act pursuant to Rule 404B. And as it has already been kept out previously, it should not be allowed back in.
It was kept out before as improper character evidence because it was being offered for that purpose, to show the impulsivity. And I do find that in this case, in the testimony of Ms. Becker, in terms of what the relationship, and that I do find some relevance in this regard. So I am going to allow it in this instance. The objection is overruled.
Thank you, Your Honor. After this incident, he then proceeded to kick you off the team and insult your friend Taylor, correct?
That's right.
And this amplified your anger, correct?
Yeah, it was not a good day.
And you did say that you would get back at Mr. Brackman if it was the last thing you did, correct?
Objection, Your Honor. May I be heard?
You may.
Your Honor, first of all, this is improper character evidence pursuant to Rule 404A. This is being offered to show that Ms. Becker would act in accordance with a hateful statement that she made towards Mr. Brackman and act in accordance with that hatred.
Response?
May I confer with my counsel once more?
Yes.
Your Honor, I am ready to respond.
Go ahead.
It is admissible under Rule 404 because it shows a plan of intent and identification.
Response from the defense.
Yes, Your Honor, one moment.
Yes.
Your Honor, the foundation has not been laid to show that this is Avery Becker's intent or the state of mind that it was her state of mind that she intended to harm Mr. Brackman.
Your Honor, I believe that proper foundation has been laid.
I'm going to allow the inquiry into this statement. I do find that it goes toward, for the reasons stated by the prosecution, it's not going toward as improper character evidence, but goes to the state of mind. So I'm going to allow the inquiry. I'm not sure if further foundation may need to be laid in terms of the statement itself, but other than that, move forward.
May I re-ask the question?
You may.
But you did say that you would get back at Mr. Brackman if it was the last thing you did, correct? Please answer yes or no.
Well, those are my words, but you're taking them out of context, counsel.
Okay, well, next you claimed that you do not know where Mr. Brackman's residence is, correct?
It's not a claim. I don't know where he lived.
But you would be able to recognize his car correctly.
Yes, that's true.
And so if you were to look up his license plate, it would show you the address of the residence, correct?
No, I don't have access to that kind of data.
Okay, well, moving on. You vandalized Mr. Brackman's car with a permanent pen, didn't you?
I thought it was dry erase marker, but yeah, I did.
But you had used these pens before, correct?
We used dry erase markers to take notes. I don't know who used a Sharpie that day.
Well, moving on. You liked your phone, didn't you?
Yeah, I guess.
And it was a large part of your life, correct?
I'm sorry, I don't quite understand what you're asking.
You used a phone a lot of the time, didn't you?
Well, yeah.
But you claimed that you lost your phone the day before the murder incident, correct?
I didn't claim anything. I lost it at the Fry Shack.
And the only person to testify this is your best friend, Taylor, correct?
Since Alex decided not to tell the truth, yeah, Taylor's the only one.
Okay, and you also mentioned you were quite good at mock trials, correct?
Yeah, I guess I was.
And you were good at luring judges, correct?
I was good at crossing and closing arguments.
Could you please answer the question?
Well, I can't answer that with a yes or no because in the context of cross-examination and closing arguments, I'd say, yeah, I was pretty good at it, but otherwise, no, I'm not.
Okay, so one more question. You refused to talk to law enforcement, didn't you?
Objection, Your Honor.
Yes,
May I have one moment to gather my notes?
you may.
Your Honor, opposing counsel is attacking my witness's constitutional right to remain silent. Under advice of counsel, my client chose not to speak to investigators, and that choice should not be attacked or held against her in any way.
Response from the prosecution.
To my knowledge, the Constitution does not apply in this case.
Any further response from the defense?
Yes, Your Honor, the Constitution applies in any case. My client has the right to remain silent under the Fifth Amendment, and she should not be attacked for that choice.
Go ahead. Did you have another response?
I am not saying that it doesn't apply in every case. I'm saying that in this mock trial case, it does not apply.
I don't know the answer to that, but whether or not it applies in the mock trial, but what I will, in terms of the context of this particular case, I am going to sustain the objection and not allow that inquiry based on the right to remain silent. So the objection is sustained.
Your Honor, I ask that question be stricken from the record.
The record will be so stricken.
Okay, no further questions, Your Honor.
Any redirect?
Yes, Your Honor, but first, may I have a moment to rearrange my virtual courtroom?
Yes.
Now, Ms. Becker, what is the context of your statement that you would get back at Mr. Brackman?
It was the night after the car incident, and I was mad that Mr. Brackman kicked me off the mock trial team, and so I was venting to my mama, and But then she set me straight and told me that I needed to apologize. And when I woke up tomorrow morning, that's exactly what I did.
So did you mean that statement?
No, I never meant to hurt Mr. Brackman.
Why didn't you notice that your phone was missing?
I was so preoccupied by everything else happening, and seeing the mock trial kids. I was still a little angry because I've been kicked off the team, and I was trying to apologize and get back on, and it was just a whole mess at that moment, and I didn't really notice my phone missing.
Was it your intention to vandalize Mr. Brackman's car with permanent markers?
No, I thought it was a dry erase marker, and all I wanted to do was, tell him that I disagreed with him, really. And after I did it, I knew it was done. It's the stupidest thing I ever done.
Finally, Ms. Becker, would you ever do something like look into Mr. Brackman's license plate to find his address?
No, I didn't know where he lived, and I didn't have any intention of going to his house. If he saw me there, he might have pressed charges for the car incident. And all I wanted to do was apologize, not scare him.
Thank you, Ms. Becker. Thank you, Your Honor. I have no further questions.
Thank you. Any further witnesses for the defense?
No, Your Honor. The defense rests.
Thank you. Does the prosecution have any rebuttal evidence? Let me see, is the person, who is the person that's going to be doing
Your Honor, we have a closing statement.
Okay, so there's no rebuttal evidence for the prosecution?
No, Your Honor.
And you may proceed with your closing argument.
Ladies and gentlemen of the jury, today I'm here to ask you to convict a murderer. Today, we saw a story of burglary turned to butchery. We heard from Detective Jordan Markowitz, who placed Avery Becker at the scene. We heard from a good friend of Avery's, Alex Cifuentes, who told us about Avery's plan to vandalize Mr. Brackman's house. We heard from Kyle Kuzak, who told us about how the murder went down. The defense tried to rebut two best friends with everything to lose if Avery was convicted, and an expert who was educated at an online school and has bad blood with the police. Today, you heard a story of a disgruntled student who attempted to break in and vandalize the home of Mackenzie Brackman, just like he did to his car. Today, we showed you the story of a burglary turned to butchery, where the phone of Avery Becker, his third kidney, showed up at Mackenzie Brackman's house, where he was found dead, where there was a struggle and Mackenzie Brackman was killed. We saw text messages from Avery Becker expressing his plan to trash Brackman's house. Ladies and gentlemen of the jury, we ask that you follow the facts and find Avery Becker guilty of murder in the first degree against Mackenzie Brackman.
Thank you. Is the defense ready for their closing argument?
Yes, Your Honor, but before I do that, I have a request for the court.
Okay.
I will request the court to allow my defense trial technician to display jury instructions and zoom into that jury instruction while I present my closing argument, specifically jury instruction 2, Your Honor.
That is fine.
And my second request is that I would like to point out that during prosecution's closing argument, there was assumed facts not in evidence pursuant to the reputation of Professor Van Owen's reputation. Yes.
I will note that. And specifically, what was the statement?
That there was a bad reputation with the police department, Your Honor.
I do find that was not evidence that was presented, and so that part of the argument will be stricken. Continue.
Your Honor, may I have a moment to rearrange my courtroom before I start my closing argument?
You may.
May it please the court. Avery Becker is not guilty. That much should be very clear at this point. She did not break into Mackenzie Brackman's house. She did not trash his house, and she did not kill anyone. The prosecution has stated over and over again that this has been a burglary that turned to butchery. However, that is what the prosecution framed Avery Becker to be. The truth is that the prosecution presented a botched investigation, and then they ignored an alibi and an alternate suspect. Keep those three in mind as the court gives you a set of jury instructions. These instructions tell you that Avery Becker, up until this point, is presumed innocent. Jury instruction 2 tells you that the prosecution has the burden and that they must prove each and every single element of the charges beyond a reasonable doubt. Now, I briefly want to talk about the concept of reasonable doubt. As Americans, we want to make sure, in fact, we want to be absolutely certain that no innocent person is ever convicted for a crime that they did not commit. An unjust conviction is intolerable and inexcusable under our system of fairness and justice. That is why the definition of reasonable doubt states that reasonable doubt is such a doubt as would cause reasonable people to hesitate to act in matters of importance to themselves. And what is critical within that definition is the word hesitate. A mere hesitation is an act of reasonable doubt. And how can you not have reasonable doubt after everything that you have heard today? At the beginning of this trial, my co-counsel asked you to keep in mind 3 important questions. What time did the victim actually pass away? The prosecution doesn't know. Where has Blair Rollins been since March 6th of 2020? The prosecution doesn't know. And how can Avery Becker be at 2 places at once? And again, the prosecution doesn't know. So if they don't know and we don't know, how can you be expected to know? And most importantly, how can you convict? I want to talk about the alibi in today's case. One of the most crucial reasons that you cannot find Avery Becker guilty is because she was with Taylor Perkins on the day in question, looking for her lost phone. Taylor Perkins has testified to this, and Professor Van Owen has testified to the CDR data that corroborates this story. And let's not forget about the alternate suspect that disappeared off the face of the earth. The alternate suspect that was in fact considered by the prosecution and then disregarded. What did the prosecution tell you about Blair Rollins? Exactly, nothing. Detective Markowitz told you that she had never heard of that name before, even though Kyle Kuzak testified to having information on Blair Rollins and corroborating Taylor Perkins and Avery Becker's story on her CSR witness tracking sheet. And then there was the awful investigation. If you are sitting here frustrated, second guessing the answer to all of these questions, imagine how Avery feels. Assumptions lead to awful investigations. In this case has been riddled with assumptions. The prosecution assumed that the phone was on Miss Becker, that the text messages came from Miss Becker, and that Miss Becker was within this crime scene. Today, Avery Becker has admitted her faults. She is human, like all of us here. We all wish we hadn't done immature acts, said something out of frustration when we were younger. We all regret those things. Miss Becker has admitted that she could have handled her confrontations differently with Mr. Brackman, that she is shameful for what she did to Mr. Brackman's car. But it ends there. So don't convict an innocent person and find Avery Becker not guilty. Thank you.
Thank you. All right, that concludes this trial. I would ask the scoring judges to please turn in your scoring sheets. Once that's concluded, then if you could turn on your videos so then we can give some post-trial comments. That won't occur until we know all of the scoring judges have turned in their scoring sheets.
Your Honor?
Yes.
I wasn't sure if the prosecution had intended to reserve any time for rebuttal.
Oh, they hadn't, and so that's why I didn't ask. So I can definitely make that request. I think that was Mr. Newman. Did you intend to do a rebuttal closing argument?
Yes, Your Honor.
I'm sorry, go ahead.
Okay. Today, the defense has said that we cannot know if Avery Becker sent texts from Avery's phone, or that Avery Becker did not have her phone. What reason is there to believe that Avery would not have her phone? As her best friend has stated, and this assumption, and for all the talk of the defense about assumptions, their entire case is based on assumption that Avery Becker did not have her phone. And what reason would Avery Becker have to not have her phone? If you listen to her best friend, Avery Becker's phone is like a third kidney to her. I think, in addition, I'm shocked that if the phone, as Miss Perkins has said, was so important to Avery, that Avery would not notice until the day after she lost her phone. And I think that if the defense is going to act all high and mighty about assumptions and how assumptions lead to a bad case, maybe they should not base their entire theory off of an assumption. Thank you, Your Honor.
Thank you. I apologize for not giving you that opportunity to begin with. Thank you, Mr. Kane. Now we conclude the trial. And now if we could have the scoring judges, please turn in your scoring sheets.
Judge, do you have access to our scoring sheets?
I do not.
Okay.
Do you need, I can contact someone if you need something from that.
I'll just, I'll text Sam because one team has more points, but then I didn't update it. So then it's the other team won.
Okay, so go ahead and we'll get that resolved before we make any comments. So go ahead and take care of that right now.
I'm still working on mine.
That's fine.
Charlotte, for what it's worth, I think the points that add up don't automatically transfer to the winner side. You have to manually do either plaintiff or defense as the winner.
Yeah, that was my issue. Like, automatically do it.
I have submitted mine, Judge.
I just texted Sam and Lance.
Okay, great. So I just got an email from Judge Timbreza. I have all 3 sheets and they're fine. You're good to go. So I don't know if you want to, if there's any other concerns. Let me just email him and say. I appreciate everyone's patience. We just want to make sure that that the scoring piece gets totally resolved before we start making any comments.
They texted me that it's fine, so.
Okay, great. Okay. Well, thank you all very much. That was very impressive. I really was I'm exhausted now. I did not expect to have so many great objections. And you guys did such a great job, both professionally, including your presentations were very impressive. I liked how everybody kept their theme throughout both cases, which was great. The witnesses just very well. And Avery Becker, there you are. Very good job. I like the way you played it as very humble. I think that was really nice. It was a nice presentation on that. But all of the witnesses did a great job of knowing their case and sticking to their guns and all of those types of things. And the attorneys, your objections were just really nice, and everybody did a really good job of being able to pivot whenever something didn't go your way, not reacting to things that you may not have liked. I was calling y'all plaintiff for the first part because I'm a civil lawyer. I've never done a criminal case, and so no one commented. So I appreciate you being nice to the judge as well. And again, just really nice job overall. I don't know if we want the other scoring judges want to make any other comments.
All right, I'll go ahead. My name is William Kane. I'm an almost retired attorney, practiced in Mesa County for 40 plus years and now living in Aurora, and have participated in mock trial for many of those 40 years. And I'd like to congratulate both teams for doing a really super job. You have a break now, so you can work on your cases a little bit this evening. And so I'll make some, what I hope are constructive comments, good and bad. I'd like to initially, and this is in part, I probably wouldn't have said this except for the fact that Judge Rubenstein is our presiding judge, and that is that Mr. Andrew made this big point in his opening about being so pleased to represent the people of the state of Colorado. And that sounded to my ear exactly like every prosecutor I've ever heard. That set a tone of reality when you did that. Ms. Malloy, I loved your opening. And this applies to Ms. Melendez, who I think did the closing. I really liked how you looped back. You had your 3 theme questions about the alibi, the awful investigation, and the alternate suspect, and then your 3 questions. And you tag teamed the prosecution in your openings and defense. And I thought that was great. I particularly liked the concept of the 3 questions that, of course, are impossible to answer. It would be a little more powerful if you explained why those questions are critical. I'm not sure that they are. I understand that they're rhetorical, but I'm not sure why they're persuasive. The prosecution team struggled with objections a bit, and in mock trial competitions, you're just going to run into teams that make objections as frequently and as aggressively as the defense team did, and you want to try to be aware of those. I think most of the character, take a look this evening at 404B. I think most of their character evidence objections are handled by 404B, particularly as to identity, since identity is disputed by the defense in every case, obviously. So try to sharpen up a little bit on your objections. On the prosecution side, I thought Mr. Andrew and Ms. Denman made a particularly effective team as attorney and witness. Ms. Denman, there were a few times when you were trying to fend off cross-exam questions about the alleged holes in your investigation. And you said once or twice things that they were not relevant to your job, and including determining a suspect is not relevant to my job. I think that's relevant to your job. I understand that you want to cover up, or you want to respond to the claims that your you didn't do a thorough investigation, but the suggestion I would make is not to claim that something's not relevant, but to have the list of evidence that had already pointed you to Avery, on at the top of your mind, so you can say, well, based on his texts, based on what he said, based on the location of his cell phone, I had all the evidence that anyone could want that pointed to Avery Becker as the sole suspect. And as to the prosecution team as a whole, and particularly in your openings and closings, I'd suggest perhaps that you think about all the things, both teams, if you're on the prosecution. Seems to me there's a lot of things that have to be true if Avery Becker's story is credible. And I think you can argue that those are not. What came to my mind immediately is that he has to have lost his phone and it was never found, that the text where he said, I'm going to go trash the house, are doctored, that there's some other person who has the knowledge that an Avery Becker would have about the subject matter of his text, that he's been kicked off the team and he's going to Brackman's house, that he's not going to be there, and that someone else would have the motive to do that, and that someone else would have to have the motive to burgle his house. I think you can make some hay on that, and it would be my suggestion anyway that you do it. I have to give credit to both teams on, so Ms. Buchan obviously set up what an awful investigation it was. And then Ms. Herman then objected that she didn't have any idea. She couldn't testify to that. So I liked the defense team for setting up that statement to fit in with their theme. And I liked even better Ms. Herman's objection, which was sustained. So it was just good lawyering all the way around, ultimately with the defense team paying for trying to get cute and setting up the awful investigation statement to fit in with their theme. I have some other notes, but I won't take up any more time.
Thank you. Great.
I'll jump in with my comments. So I actually have a phone call at 4, so I'll make this quick. Yeah, I thought both teams did a great job. If you were nervous, I couldn't tell, so good job with that. And I think you all navigated, doing this over Zoom, which is awkward. You all navigated that really well. So for the defense, I thought both of your openings and closings were awesome. I think particularly the discussion of the burden of proof and reasonable doubt was really good. And I think it, would be hard to say that there wasn't reasonable doubt here. I think the defense, I would pick your battles. You don't need to object to everything. Sometimes it's better just to, have a few less objections, and then you'll have a little bit more credibility or weight when you do object. Echoing the sentiment earlier, I think the prosecution, you guys should brush up and anticipate the defense objections. I think some of those character evidence objections, you should anticipate them in advance and know what your response is going to be. Even if you are going to win, or you think you are going to win and you should win, you should still kind of anticipate some of the things that are likely to be objected to. For the prosecution, I thought your the burglary turned to butchery was very engaging, and the opening, I was very intrigued. I felt like I was watching a Netflix, murder show or something. But I also think you want to be careful that as the prosecution, that you're recognizing that this is a murder and someone died, and you want to present it as a very somber and serious event, and not, dramatize it too much, because you don't want it to come across as you taking it not seriously, that someone died. Yeah, I think those are pretty much the main ones, but you all did great, and good job. And I'm going to hang up here, but good job, everyone.
Thank you.
So I don't have too much more to add from Bill's comments and Charlotte's comments. I thought everybody had a great grasp of the facts and was able to really think on their feet well with objections and with inquiries from opposing counsel if you were a witness. I feel like everybody had read the material and understood it very well. I would also agree with Charlotte with respect to, I think, on the defense side, perhaps consider fewer objections. I think it kind of detracts from the advocacy side of things. And then my only other comment, and this is difficult, especially when you're under the gun with time, and everybody, it's a challenge for everyone, but slow down, especially on the opening argument and the closing arguments. Just slow down so that the jury and the judge have an opportunity to let everything sink in. So those are my only comments. Great job, everyone.
Very, very good job. And I think we'll close up unless anybody has anything else that you feel needs to address or question or anything like that. I have a message. Let's see, 3 new messages. Hang on. Oh, very good. Thank you. Thank you to you all. You guys, good luck, and good luck in the next rounds and in everything you do. You guys did a great job. Thank you all.